For listing?
for listing, Lordship.
Yes, yes.
On Friday, Lordship. You can see of next case, our pleadings are already completed, Lordship.
Hmm.
But
On Friday?
Friday, please.
My lord, similar pay for listing of an IA, my lord, for declaration of result. The main case is fixed on 22nd on Friday. The IA may be.
May I please?
Yes.
My lord, item number 8, 9, and 10, my lord. My lord.
8, 9, and 10.
Yes, my lord.
They are all analogous or what?
Yes, sir. Yes, my lord. My lord, last night I could not hand over the brief to my senior, my lord. Otherwise, matter is very urgent, so it may be taken day after tomorrow, my lord.
24 matter.
Yes.
Okay.
Day after.
As prayed for by learned counsel appearing for the petitioner. List this matter. When? On 20?
21.
On, oh, matlab, tomorrow, day after tomorrow.
Day after tomorrow.
List this matter day after tomorrow, that is on 21st.
May I please, Your
Yes.
Lordship? Lordship, I beg to mention item number 18, Lordship.
18,
18.
hearing matter.
Yes, Lordship.
Hmm.
Lordship, the engaged counsel is due to medical urgency, Lordship.
No, this is not hearing, admission. Admission, yes. So what happened? Conducting counsel has some medical emergency?
Yes, yes, Lordship.
Okay, this is 25 matter. Okay, Mr.
K. Islam.
K. Islam, learned counsel appearing for the petitioner submits that the conducting counsel has some medical emergency and has prayed for some time. Prayer is allowed. List this matter when?
Lordship, 1 week, Lordship.
Huh?
1 week, Lordship.
List this matter on 9th of June.
May I please, Your Lordship? IA for implement, Lordship, filed on 12th. May come up on 22nd.
Implement.
Implement.
May I please, Your Lordship? I beg to mention, Lordship, listing for admission matter.
Please speak to the court master into it.
May it please your ladyship. Ladyship, with the consent of the other side, I beg to mention item number 33 and 34. Your ladyship.
33,
33 and 34, your ladyship.
hearing matter.
Yes, your ladyship. Ladyship, today my
I cannot
senior-
hear you. Oh, your mic is working or
Am
not?
I audible now?
Shout, you're a young girl.
Sorry.
Raise your voice.
Yes, yes.
Hmm.
Today we have some difficulty. My senior has some difficulty today, your ladyship.
Acha.
So your
BJ
ladyship may
Talukdar?
kindly- No, ladyship. Mr. J. Chutia.
Oh, the J. Chutia. Okay. But 2018 matter.
Ladyship.
So I'll take it up day after tomorrow. Will it be okay?
Is it okay if if it may be posted in the month of June, your ladyship?
But then see, such an old matter. So along with 33, 34 also goes. It's
My
a
senior
connected
has
matter.
some difficulty in the month of May, actually. your
Okay, no
ladyship.
further adjournment, huh? So learned counsel, so Miss,
Be sure, your ladyship.
we, so and so for the, tell your name properly. What is your name?
V. Shohe.
B.
V. Shohe.
V. Shoria, huh?
Shohe.
Learned counsel for the petitioner submits that the conducting counsel has some difficulty in doing the matter today and has prayed for time. Prayer is allowed as a last opportunity since the matter relates to the year of 2018. List this matter again on 4th of June, right? No further adjournment, huh?
Allegedly.
4th of June. Yes, Mr. Bhuya?
May I please, as your ladyship, my lord, I beg to mention 2 items for listing on Friday, my lord.
Speak to him.
My lord, some urgency is there, that's why, my lord. My lord, these are the issues, my lord. In the entire state, there are Kwame madrasas, my lord. And more than 500 madrasas are there under the petitioners association. But there are 3 teachers had been appointed, but they are without salary, though the fund is pending, my lord, before the government, my lord. That's why, my lord.
Okay, on Friday.
Friday, my lord. Oblige, my lord.
May I please, Your Lordship? I beg to mention for listing, Lordship.
Okay, speak to the court master, he'll do it.
My lord, this pertains to
My lord.
registration.
Yes,
My lord.
Mr. Bora.
Yes, my lord.
Yes.
Matter is regarding registration of the petitioner under the Assam Council of Medical Registration. So, my lord, actually the petitioner has pursued her studies in Ukraine. So therefore, my lord, the Assam Council of Medical Registration, my lord, sought for some clarification from the National Medical Commission. Yesterday, my lord, they have received a letter from the NMC, my lord. So they need some time, let the matter be taken up in the next week, my lord. By that time, the council will take a decision.
Good only. Let the instruction come, we can. And
Probably by that
Yeah.
time.
Clearance from their side has to come, but then I've been waiting for a long time,
Yes,
losing out on my practice actually.
Acha.
Though otherwise all regulations have been
So it's
complied.
a doctor degree.
Yes,
It's
my
a
lord.
doctor degree.
Registration.
These
Huh?
people,
Hmm.
these people actually, while studying in Ukraine, earlier they had to just come and clear an exam here. But during the Ukraine war and pandemic period,
Oh.
people
Offline class.
missed classes and offline classes were held. So
Oh.
there was a issue, my lord, where offline classes had to be compensated by subsequent online classes. So whether that has been done or not is the issue, my lord.
Acha.
So my certificate says that I have sufficiently compensated. So if that be so, there is actually already a clarification from their side on 18/3/2026. What sufficiently compensated means.
So let him bring the instruction. Mr. Bojo, you got your instruction today.
Yes, my lord, with regard to the present petitioner, as well as 3 other MBBS students in the state of Assam who are seeking registration within the state of Assam, that query, my lord, my learned friends department had sent to the NMC. I have the letter, my lord. On 14th, all the 4 candidates' issues have been addressed and the communication has been sent to the concerned department. Now, they will take action upon it. That was sent yesterday to them. They will act upon it now. Primarily, we're waiting for this only. So this has already
Is
been
it
done
a-
on the 14th.
If it is a yes, then there's no.
Probably it will be
That
yes.
has reached them, my lord. So that is what the instructions are at my end. So possibly on the next day, lordship, we might come to a logical conclusion
My
on
lord.
this one.
So let the-
Heard Mr. B. Pathak, learned counsel for the petitioner, and Mr. D.P. Bora, learned standing counsel health department, and Mr. D.K. Buddha, learned standing counsel for National Medical Commission. Mr. D.P. Bora, learned counsel submits that necessary instructions with regard to registration of the petitioner under the what? Registration of the petitioner under the Assam Council of Medical Registration has been received by the
Assam Council of Medical Research.
no, but with regard to the registration of the petitioner under the so-and-so, the instruction has been received by
My lord, instruction has been dispatched from the NMC to the Assam Council.
NMC is acha. Is instruction? The 51 to needing. Otherwise, I forget. Okay, instructions has been ki kolo has been received, and for further instruction you have sent, right, to
No.
get something.
We sought for some clarification or queries that we have received. Now we will take a decision, my lord.
For which they will so and so has been received, and in that they will take a decision on the said instruction, and has sought for some time. And what has Mr. Boido got to do with that instruction?
Now nothing, my lord.
Acha.
Their part is
For
complete,
power
my lord.
parties, my lord, we have dealt
Acha.
with.
You have received the instruction from them.
Yes, my lord. Yesterday we have received.
The said the said instructions were received from the National Medical Commission. Prayer is allowed. List this matter on
On 29th.
29th of this month,
Yes.
Friday, on 29th of this month.
Oblige, my lord.
36. Motion. Yes, Mr. Banik, congratulations from my side.
May it please your lordship. My lord, this issue in the writ petition is basically a decision by the authorities to shift a school from place A to place B. It sounds simple, but it's
Shifting the school.
It's a school. It's a high
Mm.
school, provincialized high school. Shift. Earlier, it was a madrasa. So when it was a madrasa, it had the different acts following. It was provincialized as a madrasa. It had different set of acts come. Then with the Act of 2020, the madrasas go back. It becomes a provincialized school under the. Now, school would have three components: the teachers, the students, and the school itself.
Teachers, students, and
The school itself. So far as the students are concerned, depending on the numbers going low, government has a right to take a call. We would go for amalgamation or merger. As your lordship knows, in case of amalgamation, school A and school B comes together to form school C. There are notifications, guidelines, acts, laws to say what would happen to the existing teachers, how they would be accommodated. In case of merger, A becomes B, loses its identity, or B becomes A. Again, the same rules would apply so far as the teaching staff are concerned, the students are concerned. Here we have a case of none. Here we have a case of shifting simpliciter. In case of shifting, or in case of amalgamation or merger, there's a requirement in law. We are aggrieved by the order
of shifting.
which have of shifting.
Why did they shift? What is the reason given?
At
Students
page
have come
70
down.
Nothing of that sort. This is a unilateral call by the headmaster, mooted by a projected proposal, which in turn has been accepted by the inspector of schools of the concerned district circle and given a green signal by the director secondary education Assam. It's just not that it happens as per law. May I read and may I invite my ladyship's attention to page 17 for a moment, 17.
Hmm.
May I?
Hmm.
The proposal for shifting of SKFJ High School to the newly proposed land of Fatehpur under Sribhumi district, submitted by the Inspector of Schools, Sribhumi, vide his letter number so-and-so dated 18/7/25 and 11/2/26, and resolution of the Managing Committee, guardians of the school under Sribhumi district is hereby approved. All right. So proposals, resolutions, and approval comes into. May I invite my ladyship's attention to the Assam Education Provincialization of Services of Teachers and Reorganization of Education Institutions Act, Run 17.
One
If you're
second.
holding
I'm
the
just.
same book,
Yes,
119.
yes. 119. Okay.
11.
Hmm.
Because now, till 18, the madrasa would be there.
Hmm.
With the Act of 2020 coming, all madrasas would go. So we'll fall back on this act.
Yes.
Page
119.
Page 119.
119.
119.
Hmm. It is the part of the act.
It's a part of the act. I'm referring to the section
Yes.
12.
Yes. Okay.
Mary.
Hmm.
In appropriate cases, if there is already an existing educational institution nearby and the enrollment of the students do not justify for more than one institution in the same locality, or there are other sufficient reasons to do so, the state government, in the public interest and for reasons to be recorded in writing, may order for transfer or shifting of the institution and the incumbents of the institution from one place to another, or may order amalgamation or merger of two or more existing institutions as per Shiksha Kshetra scheme. My leadership, amalgamation and merger, we are out. It's on shifting simplicity. The requirements are, in appropriate cases, if there is already an existing educational institution nearby.
That is not the case.
That is not even reflected. So it falls on the first requirement. Second, and the conjunctive requirement of and is, and the enrollment of the students do not justify for more than one institution in the same locality. That is even not reflected. So condition one has to go parallelly, conjunctively with number two, so as to satisfy the norm. Now come to the or.
So both the things should be there. It's
Absolutely.
not or.
Now we come to
Or.
or. Now it may not have it,
Mm.
but the first one should be there. If there is an already existing education institution nearby, that has
No.
to be there. We
In
can-
the first two requirements will go together.
First
But-
will go together.
Huh.
One, it's like question number 4A and C
Mm.
or 4B and C.
Mm.
But with A, it can come B or C.
Yes.
But even if I do not take the first two and only simple, I take the third,
Mm.
may I just go to the third one?
Perhaps that will be allowed.
No,
Or
there are sufficient grounds to do so.
regions
What
to do
happens is,
so.
there's a flood in the Brahmaputra. The land is eroded.
Mm.
The land is taken for a highway. It has to be evacuated.
Mm.
It has to be given as a grazing ground, etc., etc. Those also reasons must have to be recorded
Mm.
because this is not amalgamation or merger under the Shiksha Kshetra
Yes.
scheme.
It's
This is shifting.
shifting.
Now
Mm.
they put the cart before the horse. What did they do? By this order
Mm.
at page 70,
Mm.
it says resolutions of managing committee.
Mm.
Now, shifting cannot be mooted by the resolution of a managing committee. Number one. Number two, those submitted by the inspector of schools and approval by this. This is not the way done. The government has to take a call on its own.
Now, do you have the resolution with you?
No, we don't have a resolution. What we are on is that the order on the face of it, ex faci, is bad in law. It
But
moves.
there will be some reason behind.
What I'm saying is that
Mm.
so far as this order is concerned, it is proceeds on the request of a, in the form of a resolution. I am not challenging the resolution. What I say is that the shifting of a school by an authority on the proposal of a resolution is not what is there in the law.
Mm.
It has to be by the government on the reasons given.
Mm.
And if my leadership would have the petitioners who they are at paragraph 2,
Mm.
page 5. This is more important.
So this what? These are the petitioners you are
Petition-
showing.
More important.
Huh.
That the petitioner number 1 is the president of the managing committee of South Karimganj Faizia Zila High School, Hakin. Number 2 is a social worker of the locality. Number 3 is a guardian of a student of the said school. Number 4 is one of the member of the managing committee of the school.
So they are challenging that.
We are saying this is nothing there. Even if you stage managed it, it is wrong. Now the reason.
Since the members of the managing committee has come before this court, and in page 17, what we see is the approval of the resolution of the managing committee.
Yes. And what happens is, we have written at page 19.
Hmm. Yes.
Page 19,
Hmm.
this was written by us to the district commissioner, Sribhumi.
Hmm.
The relevant would be at page 21.
Hmm.
This is where things turn sour.
Hmm.
Page 21, third subparagraph, that sir.
Hmm.
May I read that?
Hmm.
That sir, the said headmaster for his vested interest and malafide intention with a view to misappropriate the fund of the building sanction approximate amount of more than 3 crores, started a game plan for shifting of the school place by creating false gift deed and in collusion with the miscreants and by false representation obtained a fitness report arbitrarily shifted. This is what is happening. May I pray?
So according to you, it was all done by the headmaster.
Yes. We are
And
let the government take a call. Yes. Tomorrow government says for ABC reasons we need to shift. Maybe we have to go
school
back.
is still there
Yes,
at the
yes,
original place.
Students are there. More than 400 plus students are there. I'm praying to interact them, protect.
Yes, sir.
Madam-
He is praying for interim. By the in the meantime, you bring your instructions, but
Yes, yes. In the meantime, I have to take instructions.
but what about the interim? Because there is a clear violation of the
After
law.
receiving the instruction, my lord, yes, because page 17, my lord. It is duly a resolution of the managing committee and guardian of the schools.
Hmm.
So it is stated here, as per resolution of the managing committee and
See,
guardian.
the managing committee member, guardian of the student, they have all come up by this writ. So it cannot be said that it was a resolution of the managing committee. There's something fishy about it. There's something more into it.
So we say can't be
That is
done that
why
way
my-
also. Resolution, by a resolution, you cannot move a proposal for shifting.
Yes, by
Now, when a
resolution
suitable
also
so-
cannot.
That is why, my lord, the instruction is required from the department, my lord. And therefore, on next date, interim may be considered after receiving the instruction, my lord.
But the process of shifting has to be stayed if it is against the law. Let me stay this order 17,
Well,
and then you bring the instruction, we'll finally dispose it of.
as soon as possible,
Yes.
as soon as.
Third, Mr. S. Banik, learned counsel for the petitioners. And Mr. U. Sharma, learned standing counsel for secondary education, right?
Secondary Education Department.
Secondary education. By this application filed under Article 226 of the Constitution of India, the petitioner has prayed for cancellation of the impugn order, dated 24/2/2026, by which it is stated that as per resolution of the managing committee, the proposal of shifting, as per resolution of the managing committee, to the newly proposed land submitted by so and so, the proposal for shifting of SKFJ High School was entered into. What proposal has been taken? Proposal for shifting of so and so school to the newly proposed land. To the newly proposed land of Fatehpur under Shribhumi district has been taken. Any other order, any other challenge?
Nothing.
Acha, not to rescind and all. Acha. The case of the petitioner is that case of the petitioners is that the petitioners being the one of the petitioners being the president of the managing committee. No, this is South Karimganj Faze Jalia Sim, no?
That's
SKFJ. Okay.
That,
One of the petitioner being the president of the managing committee of the said school, and the other four are and petitioner number 2 being a social worker. Petitioner number 3 is a guardian of a student studying in the same said school, and petitioner number 4 being one of the member of the managing committee of the school, is that the said school, that is South Karimganj Faize Jalilia High School, was earlier a madrasa, and later on it was converted to a regular school.
yes.
It was
coming into.
converted to a regular school with the
after
act.
The Assam Repealing Act 2020.
With the act, that is Assam Repealing Act 2020 coming into force, and the said school was running in the what place?
Tigumi district.
Was running at Shribhumi district
Oh,
at a particular place. However, on 24/2/2026, a proposal was submitted by the Inspector of Schools, Shribhumi, by letter dated 18/7/2025 and 11/2/2026, for shifting of the said school to a newly proposed land of Fatehpur. What did I say? Submitted. Proposal was submitted, no, by the by the inspector. And the said proposal was approved by a resolution of the managing committee, as well as the guardians of the students of the school. The learned counsel for the petitioner, however, submits that the said exercise of shifting was against the law, more particularly Rule 12, Section 12 of Assam Education, within bracket provincialization of services of teachers and reorganization of education institutions, bracket closed, Act 2017. According to the learned counsel, the shifting can be done on sufficient reasons, and that too by the state government in the public interest, and for regions to be recorded in writing. Whereas in the instant case, the proposal was mooted by the inspector of schools, and it was approved by the managing committee of the said school, which is against the said provisions of law. Further, the learned counsel submits that the decision to shift the school was actually of the headmaster of the said school for extraneous purposes, and that it was not by the managing committee also. Not required, they cannot.
With an apology,
Mm.
what had fallen from your lordship, there needs to be little correction on the facts.
Mm.
That is, it was by the resolution of the managing
Mm.
committee, which was submitted by the inspector and approved by the director.
Director.
আচ্ছা ও আচ্ছা আচ্ছা হ্যাঁ হ্যাঁ এটা অলপ ভুল হৈছে হা you say that it was a last line to the kolo it was the
Mooted by the resolution of the managing committee.
yes, the proposal was mooted by the resolution submitted
It is submitted.
by the
The resolution was submitted by the inspector.
the resolution was submitted by the
Inspector,
inspector.
and in turn,
Acha, was mooted by the inspector of schools on the basis of the resolution of the managing committee,
this was a
as well as guardians of the school. Headed one upon variable changeover. And approved by the director of secondary education Assam.
So there was no act independently on the part of the state government as per requirements of section 12 of the act. That's
And as such, he submits that the exercise was not according to Rule 12 of according to Section 12 of the said Act. And of course, Section 12, the first two requirements will not come into effect, right? Will not be
Yes.
relevant in
It
our
comes-
purpose.
or doesn't come. It has to be the state government in the
Mm.
public interest, reasons to be recorded,
Mm.
what the other reasons would be. That much. It cannot be from the school end.
Acha, then issue notice,
Notice.
returnable by 3 weeks. Any private respondent to be served? No. Headmaster is there.
Yes.
So you are appearing for 1, 2, 3, 4.
No, no, I am for the 1 to 3. Inspector of school.
Inspector of schools who will appear?
1, 2, and 4.
I am appearing. Inspector of school, Director of secondary education, and secretary.
My friend,
commissioner.
1, 2, and 4.
1, 2, and 4. Mr. U. Sharma appears for respondent number 1, 2, and 4.
And 3 is there.
Miss S. Kumar, learned counsel, Razil standing counsel appearing for respondent number 3. Full stop. The petitioner to take steps for service of notice upon respondent number 5 by speed post with AD as well as by usual process. Extra copies to be furnished by the learned counsel for the petitioner within a day or within 2 days from today. Heard on the interim prayers on the facts and circumstances mentioned above. More so, in view of the provisions mentioned in Rule 12, in Section 12 of the said Act of 2017, the 17, the notification, the order dated 24/2/2026 is hereby stayed until further orders.
Grateful.
Until
Only the
further
memo number may be
orders.
indicated.
Uh-huh.
The memo number may be directed to be indicated. It will.
Or memo
it's a
number did
memo.
huh?
Grateful.
Dated by memo number dear E capital E dash 695881/57. Dated 24/2/2026, issued by the director Secondary Education Assam, is hereby state until the next date or until the next date of listing.
That's not problem.
List this matter on 17th of June.
17th of June.
Okay. 17th. Okay, 17th of June.
Great. Item 2.
We are praying for filing of an additional affidavit, Your Lord.
Additional affidavit.
Yes, Your Lord.
You are for petitioner. They have filed their AO.
They have filed, we have filed a reply also.
Oh,
In the meantime, we have come across certain documents we would like to bring on record.
okay. Heard Mr.
KJ Saikya, Your Lord.
KJ Saikya, Learned Counsel for Petitioner, and Miss P. Das, Learned Standing Counsel for Elementary Education or Secondary Education.
I'm appearing for one, Your Lordship. Here, Your Lordship, SSA is the main party here.
Representing respondent number 1.
Only
One.
Yes, Your Lordship. SSA is the main party.
So SSC will be appearing for all 2 to 7.
Yes, sir.
SSA has filed their affidavit also. Your Lordship.
So who is appearing? Who appears for SSC?
Not sure if I had spoken with Mr. B. Chaudhary.
Turbo
Chaudhary.
Shiksha something.
Bikram Chaudhary.
Samagra Sukhani.
B. Chaudhary.
Miss B. Chaudhary for respondent number 2 to
Mr.
7.
B. Chaudhary.
Mr. Mr. B. Chaudhary for respondent number 2 to 7. Mr.
KJ Saikya.
KJ Saikya, Learned Counsel for the petitioner, prays that although he has filed his reply affidavit to the affidavit in opposition filed by SSC, but he requires to file an additional affidavit bringing into record certain documents. Prayer is allowed. List.
Sir, I'm also praying for calling of the records pertaining to the salary structures of the petitioner.
That prayer is already there. Call for the records, right?
See.
List this matter on. When can you file it?
Also, after 2 weeks, if I may. pray
List
for-
this matter on 8th of June.
If I may pray for 12th, Your Lordship.
12th. Okay, 12th of June.
Deeply
Yes,
obliged.
Mm.
You file what reply,
Mm.
affidavit they file.
Reply to the AO.
Yeah.
To the AO.
Yes.
There are two.
IS, Your Lordship, respondent number 3,
Three.
we have filed our affidavit, Your Lordship.
Mm.
There are certain documents there, Your Lordship, that already given to the office, Your Lordship. So, Your Lordship, there are no original documents is there in our head, Your Lordship. That was already submitted long back, Your Lordship. One earlier order has been passed for which your lordship, director of pension, dated your lordship.
No, wait, there are two affidavits, both by the petitioner. Or what? Yes, I am the petitioner.
If it starts from 46 onwards, your lordship. 46 to 51. IS, your lordship. Respondent number 3. File their affidavit.
No, this 46 is again petitioner.
Can I get petition?
Additional affidavit bringing on record the steps taken by the petitioner in terms of so and so.
Documents, some records. Wrong file or this. Full file this is 7.
Both the affidavits are by petitioner.
Petitioner number petition number 6910/2022.
What number? The number of this petition?
Yes, your lordship.
6910, yes.
46 onwards, I have served your lordship to them also, same.
You check it by yourself. Say check it. Yes, I can't tell.
Yes, sir.
It is 46.
File to, sir. Pagination number to reflect mechanism query. এখন তোমালোকৰ নেকি? হা? তোমালোকৰ ঘৰ? It was not coming to the records, your lordship. Our
Have you filed it?
Yes, your lordship.
And see the office note also, it is reflected no counter was filed.
Lordship, already we have filed and your lordship copy has already served.
Copy was served to you.
Yes.
You check with your records.
Yes, your lordship. I have checked it, your lordship. The affidavit which we filed, it was not placed on record, your lordship. This note to hit with, yes.
So petitioner's counsel, what do you want to file?
Since it's not in the record, so we'll file my 2 weeks maybe time given.
Okay, you check with
Yes,
with your records and find out.
Registry, your
Heard, Mr.
Elect.
L. Deca, learned counsel for the petitioner, and Miss P. Das, learned standing counsel for the secondary education. Miss P. Das submits that the department has filed the affidavit in opposition, but on verification, it is found it is found that the said affidavit is not on records. As such, Miss P. Das is directed to verify with the registry as to the said aspect. Your for?
Lordship, I am M. Das, appearing on behalf of SK Medi for respondent number 5.
Respond number 5. Who else are there? Respond number 5 and Miss presents to report likhi diba. Miss
M. Das, your lordship.
M. Das for M. Das learned counsel appearing for Mr.
SK Medi.
SK Medi learned CGC. And what about yes, Miss S. Kumar for respond number 4. Inspector of schools also. Miss P. Das, we are appearing for 1 and 2.
I am appearing for your lordship 1, 2.
1 and 2, I think. Treasury office, Mr.
No, your lordship.
Yeah. Miss so and so RM Borua appears for respond number 6. So only one left is the inspector of schools.
I am appearing
Oh,
1, 2,
you
and
can
3.
appear. Acha, acha. 1, 2, and 3. Huh?
Yes.
List this matter on. You verify and let us know.
Yes, your lordship.
1st of June.
Yes, your lordship. Deeply obliged.
In the first case related to provisional pension,
Uh-huh.
the first case 4451, item 4, related to provisional pension, your lordship.
Provisional pension.
Provisional pension, I have challenged a wrong fixation of provisional pension. The response has been filed already. And in the second petition, 1743/2026,
Mm.
the AG, Accountant General, they have wrongly fixed my PPO and the gratuity amount, your lordship. So response has to come from them.
After notice, first time is.
Let them.
In
file
item, in the second item.
Second item.
Yes.
Well,
let
In the
them
first
file their
item, the pleadings are over.
First pleadings.
Meetings are over. So let them file their response. And in the meantime, since I am in financial hardship, I may draw the current salary what they have fixed, your lordship, and the gratuity amount.
Current, what salary? Current pension?
Pension, current pension and the gratuity amount for as an immediate financial expense, your lordship. They are already processing only the current pension and the gratuity that should not prejudice my case, your lordship. That they are okay. And that party about only 3 months. 3 months substantial allowance is there, your lord. While I was suspended.
Suspension.
Yes, your lordship. That has not been paid. I'm giving the day, period.
Hmm.
It is from 9/11/16 to 9/2/17, about 3 months. 4 months.
Subsistence allowance, that also you have not been
Not
paid.
yet been paid, your lordship. The long back, your lordship.
And your suspension, there is no question of your regularizing the suspension period and all.
That's the thing.
Upon regulation, they will grant me regular salary, your
That
lordship.
aspect is also,
That is also my prayer, but at the moment, your lordship, they can pay me the.
Also,
subsidy
first case,
allowance.
I will have affidavit, lordship. In the discussion, we will file our affidavit and.
Yeah, by right, your
okay,
lordship.
heard Mr.
Armajumdar, yeah.
R. Mojumdar, learned counsel for the petitioner. প্রথমটোত লিখিবা, huh? And Mr. S. Bhuya, learned standing counsel,
Higher education, lordship,
learned standing counsel for higher
for
education.
one go.
Yes. It is noticed that affidavits are exchanged between the parties and the pleadings are complete in the instant case.
No, in WBC 4451/20.
4451 in the instant case, and the matter is to be taken up for hearing. Admission hearing.
Analogous.
Admission hearing, huh? The second to likha. The heard Mr. R. Mojumdar will likhiba. And in this matter, the respondent is yet to file the affidavit, and as such, Mr. S. Bhuya, learned standing counsel for higher education, prays for some time to file their response. Prayer is allowed. List this matter on 12th of June, 2026. Mr. Majumdar, learned counsel for the petitioner, however, makes a prayer that
Trial of the current pension and the order.
এইটো তুমি আগত লিখিবা. This order will be in the first case.
No, second case.
Second case. Mr. Majumdar, in the কি কলো? Makes a prayer that
Trial of the current pension.
makes a prayer that the petitioner is facing acute financial hardship, and as such, the current pension,
Order pension.
whatever is calculated,
And as well as the gratuity.
whatever is calculated by the authorities, as well as the subsistence allowance,
And gratuity.
subsistence allowance for the period of the pension, for the period of suspension, that is from
9/11.
9/11,
16
16 to
to 9/2/17.
9 to 17.
17, 3 months.
May be paid to the petitioners. Full stop. Mr. S. Bhuya, what do you say on this?
Lordship, regarding current, the PPO, the current, that should be, but other pay, gratuity, other things, that thing.
already been awarded.
But
There,
one thing, Lordship, today's difficulties, my difficulty is this case is conducted by the Upamanu, Lordship. That,
So only-
third of the AG,
no,
he
no,
has nothing to say.
I
So whatever it is, let your
Taluka will say.
let your current pension be paid.
Only-
Gratuity and all, we will leave it for
They are
later
only
date.
Processing. They
But
are
I
not
said,
prejudiced
today's
by-
my difficulty,
Yes,
Lordship.
yeah.
The Upamanu is mainly, that's the.
But to,
It's by AG, not by him.
may
But
be
I
paid to him as may be paid to him since it is in the process,
According general.
since it is in the process as submitted by the learned counsel. Since it is in the process of since the same is being processed,
For release of.
since the same is being processed as stated by the learned counsel. Mr. S. Bhuya, however, submits that the current pension may be paid to the petitioner, but as far as the gratuity and the subsistence allowance is concerned, the same may be considered after hearing the entire case.
Your lordship, what?
As such,
Sorry.
this court directs that the current pension as calculated by the authorities be paid to the petitioners
As well as the gratuity, your lordship. That is under process.
under process, so they will pay. It's okay, matter will come up then again. you-
And regarding substantial allowance for
That-
3 months,
On
that
12th.
is not while service under the education department. That was while I was posted as APS.
But again, you know that subsistence allowance, sometimes the office does not pay and you have to make a prayer. So we will see during the hearing of the
is
case.
Where is there?
Okay, we will see during hearing, but as far as current pension, they cannot deny you.
Yes, yes, yes.
Yeah. So list
But
this
here
matter.
you said that is under APSC.
List this matter, when did I say? 12th of June.
All right.
May I please, Your Lordship? My lord, Your Lordship, may I kindly peruse the order dated 9/2/2024, Lordship.
9?
9/2/2024. The authority is required to file a detailed affidavit, Lord.
Here we have filed our affidavit, my lord.
You have filed.
Yes,
They have.
Not
filed
detailed.
earlier, 9/2/2024, it is very much clear, Lordship. They have filed a preliminary affidavit. On our Lordship, learned AG appeared in that, on that day, Lordship. And 9/2/2024.
Here we have not filed in detail, my lord, not para-wise comment is there, my lord.
So after this, you have not filed.
We have filed on 7/2, my lord.
No, after that.
7?
Two. After this, that was not. 9/2.
7/2 we have filed,
7/2.
my lord,
So 2 days before this.
my lord.
So because by that order,
My lord,
the
we-
learned AG submitted that state will file a detailed affidavit justifying incorporation of clause 3.
My lord, we'll file. I'm
File it.
I'm sorry, ma'am.
You have to show the justification
My lord,
why you have included clause 3 in the advertisement of this language,
my lord.
medium of language.
Ma'am.
heard Mr.
N.H. Bobby.
Uh-huh.
N.H.
N.H. Barbhia, learned counsel for the petitioner, and Mr.
P.K. Boraman.
P.K. Bora, learned pending counsel for elementary education department. By the last order dated 9/2/2024, now like by the order dated 9/2/2024, it was reflected that the Advocate General of Assam submitted by the order dated 9/2/2024, it was reflected that the Advocate General of Assam submitted that that the state would file a detailed affidavit justifying the incorporation of clause 3 in the advertisement dated 26/12/2023, which provided that the applicant applying shall match either the language 1 or language 2 of the ATET or CTET with the medium of instruction of the school. However, when the matter is taken up today, the learned counsel appearing for the secondary education department, elementary education department, prays that he may be given some more time to file the said affidavit. Prayer is allowed. List this matter
After
on
2 weeks, ma'am.
3rd of June, 2026.
May I plead your lordship? Lordship, in this matter, we have not received any instructions, so some time may be allowed to file our affidavit.
Now, my lord, this is regarding, my lord, non-payment of salary as well as the pensionary benefit. Now, the
Earlier, 3 weeks time was given.
who third, my lord, he died. Now, his wife before this honorable court, since 2001 till date, no such.
The employee died in harness while he was in duty, but no compassionate appointment nowadays. So he did not get salary. Now she is trying, she is also not getting. So you were given 3 weeks time.
It was provincialized in the year 2021, my lord. My lord, as per the appointment order, my lord, it is clearly reflected that, my lord. Kindly see, kindly come to page 14, my lord.
40,
14, 14.
1/4.
His service was provincialized as a tutor.
Hmm.
And my lord, as per the appointment order, my lord, kindly see paragraph 6. Any tutor who has already acquired the qualification required as per NCT guidelines and service rules in force on the date of issue of his or her appointment order shall be entitled to pay and allowances of a teacher from the date of issue of such appointment order, my lord. So, my lord, as per the appointment order, my lord, the
So
pension-
but the petitioner did not have that qualification.
my lord.
You are having the qualification.
My lord, that is why he was appointed as a tutor, my lord, not as an assistant teacher, my lord.
He's a graduate. Now,
So,
his style of.
Any
appointment is to make
tutor,
appointment as a
he was a tutor.
Yes, my lord.
tutor.
Any
He
tutor who
was
has.
appointed, his service was provincialized as a tutor.
Acha.
Fine, I am tutor. But what about my salary? Give me my salary as a tutor. You cannot deprive me from the salary as a tutor. What
That's
fees
a
some
simple
people
prayer.
for, my lord.
Hello, so-
Salary you cannot deny.
Yeah.
No, no.
His services was provincialized as a tutor, so there is no question of denying.
So, some time may be allowed.
Okay,
Now,
heard
reading
Mr.
for this honorable court with my lord, two minor children since 21 without single penny, my lord. Now cash is spending since 2021. Now present cash is
Why
spending
he did not receive salary as a tutor while he was alive?
because there is an litigation before this honorable court. My appointment was challenged somebody else. Would was pleased to direct the respondent authorities to make it, my lord, dispose of, directing that after hearing the parties, make a dispute resolution, they make a settlement and pay the salary. But despite the order, they have not paid my salary. There is an order we have annexed there.
So because of that litigation, it was stopped.
Yes.
And then the court ordered to pay.
Yes,
So, but then they did not.
yes.
Okay, you file your. So, heard Mr. M.U. Mondal, learned counsel for the petitioner. And on the prayer made by Miss
And Pukan.
N.
Pukan.
Fukan, learned counsel appearing for elementary education.
Yes, ma'am.
Learned standing counsel, a further time of 2 weeks is given to enable her to file her response. However, it is seen that on an earlier occasion also, time was granted to file the response. As such, only 2 weeks' time is given and no further adjournment would be given on the same said ground. List this matter on today's 19th. So, list this matter on 5th of June, 2026.
Developers.
Yes, Mr. Datta.
This is with regard to my lord, grant of scale, the petitioners, what had happened, they were actually initially.
But then the affidavits are they filed?
So the affidavits have been filed, but these are on piecemeal basis, my lord, it doesn't disclose the entire picture. The finance department is saying that the proposal is awaited from the education department. The education department, my lord, an internal communication, my lord, from the directorate to the secretary saying, my lord, that they have sent the proposal. But thereafter, there's nothing, whether the secretary has sent the proposal to finance department, that's not very clear, because the finance department clearly says that no proposal has been received. And my lord, the other issue, my lord, there are two issues, in fact. What the petitioners.
So both Mr. M. Datta on the other side, on the either side?
PP Dr. and
Oh, yes, PP Datta, of course.
But
So no,
Yes.
by the last order, what I'm saying is to place the matter before the finance department, yes.
That's what.
So any instructions with regard to the same?
That instruction I am still awaited, Lordship, but there is no dispute that they are not entitled. But thing is that how and when that amount will be released to the petitioners. That instruction is still awaited, Lordship. So I mean, under at least 1 week time, I will get the instruction.
because we're 6/2026, my lord.
You are for secondary education.
We have forwarded all the proposal to the
But
secretary.
Terangpi appeared on the last date
Yes.
and she said by placing a communication 4/2/2026 submits that is under consideration and necessary steps would be taken within a period of 3 weeks to place the matter before finance department.
So it's almost 3 months now, my lord.
Yes, Lordship. I apologize for that.
So 3 months now and no instructions are
Some
forthcoming.
miscommunication from our side also.
There was already a communication on 4/2 that the grievance of the petitioner is under consideration
Lordship,
and it was placed before the finance.
one that may be fixed, Lordship. After 1 week, I will get the instruction.
What instruction you will have?
That
What
is-
finance department
Yes,
did?
Yes, what is the present status of his proposal, Lordship? That's enough, Lordship.
Only 1 week. You place it.
After 1 week, Lordship. Any date.
Heard Mr. M. Dr. Learned Counsel for the petitioner and Mr. P.P. Dr. Learned Standing Counsel for Secondary Education Department. Mr. P.P. Dr. submits that he may be allowed 1 week's time to place the instruction with regard to the proposal submitted by the petitioner, which was under consideration as per the last order.
Lordship.
Accordingly, time is allowed. List this matter again on 28th of May or 29th.
28th May, maybe the.
Oh, yes.
Yeah, it may be, my lord.
So
After that-
26th of May,
Lordship, prior to that, I will be out of station.
26th.
I will be out of station, Lordship.
So prior to that will be this week only, no?
No, no, Lordship. After that, Lordship. After
Acha,
20,
so 1st of June.
Lordship.
First of June, my lord. Deep level.
In this case also, Lordship,
Hmm.
we have been directed to file affidavit in opposition.
Hmm.
We have received instruction, but some clarification was sought for, but that clarification is not received yet, Lordship. That's
Last
why
time you said you have
yes,
this.
I am unable to file the affidavit, Lordship. It is the fact, Lordship. Lordship,
So 1 week.
Lordship.
Mr. R. Ali, learned counsel for the petitioner, and Mr. P.P. Datta, learned standing counsel, secondary education. Mr. P.P. Datta submits that although he had received his instruction and he was supposed to bring the said instructions by putting the same, he was supposed to incorporate. He was supposed to incorporate the said instructions by way of an affidavit. But today, when the matter is called up, he submits that he had sought for certain clarifications from the department and was unable to file the affidavit, and as such prays for further time to file the same. Prayer is allowed. List this matter on 1st of June,
Lordship, obliged.
2026. By which date the learned counsel would file the affidavit.
Lordship.
Yes, Mr. Singh.
My lady, the present case is about non-payment of arrears of salaries for the past 1 year. Notice was served to them, but they haven't submitted an affidavit in opposition. The case is simple that.
They have not submitted.
Yes.
Lord, my lord, I pray for some accommodation, my lord.
Who
You are for elementary.
Elementary, my lord.
more than 4 adjournments have been seeked on their behalf, and I must
Last
pray
week.
that some kind of.
Lordship, kindly peruse the last order, my lord, last.
No, last order, yes. The bench did not take up, and thereafter, then the order before that, you were not there.
My
The day before, but 28th.
Time was not there.
my lord.
3 weeks' time was given, of course, on 28/5. Right.
I pray.
Heard Mr. What Singh?
Arsing.
R. Singh, learned counsel for the petitioner, and Mr. B. Talukdar. BJ, no, B. Talukdar, learned counsel, learned standing counsel for
Elementary education.
elementary education. Mr. Talukdar submits that although time was taken to file the affidavit, but due to some genuine reasons, he could not file it and has prayed for some further time to file the same. The present matter relates to non-payment of salary for how many days?
close to 18 years. From 2000.
2002, my lord.
2000 until 2020.
What happened? You are working on contractual.
No, they are
No.
illegal,
I was
illegal teacher, my lord.
Oh, so you were not paid a penny since the day you have worked.
No, I was paid until 2001. Thereafter, my payment was stopped. But thereafter, I continued my service without payment until 2021, where in 2021, a new notification came through which I was given.
So 1 to 21, you not paid anything,
Nothing. And
you kept working.
No, in the meantime, we filed a case, 58 ATA, administrative tribunal, where we were given a favorable order where it was directed to them to pay to us. And in
Acha.
2019, an RTI replied.
Acha, okay. For non-payment of salary, enake di diya, huh? As such, it is directed that the learned counsel for the elementary education would file the affidavit positively by the next date fixed.
If they fail, then it must be decided on the basis of the materials available in hand, because.
And in event of failure, this court would decide the matter without the same.
Fine.
List this matter when?
After 2 weeks, my lord.
List this matter on 3rd of June.
My lord.
It may be after 6th of June. Possible.
Okay. list this matter on 8th of June.
Obliged.
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 Please, Your Lordship, my lord. My lord, in this case, my lord, this case is already settled, my lord.
Uh-huh.
Two names were forwarded, my lord, by the district level scrutiny committee.
Two
Take-
what names were converted?
Two names were forwarded, my lord, for provincialization of
Oh.
service under the 2017 Act, my lord.
For provincialization, two names were forwarded.
Yes.
Kiyo শুনা নাপাওঁ ভালকে মাইকটো?
Am I audible now, my lord?
But some part it was not. So there's something wrong with the mic. It should be of a loud sound, right?
Yes.
Then
I'll take your lordship to page 29, straight away, my lord.
also affidavits are not there, not required.
Affidavits are not required, absolutely, because this court has already disposed of, my lord, this case, discussing everything in detail, and with a direction to the concerned director to provincialize my service within a period of 2 months, my lord. Again, there was a violation, my lord, stating the same reasons that
They had
my-
rejected.
yes, they have rejected, taking the same stand. I'll take your lordship to directly to the disposal order, my lord. Yes.
So who is appearing on the other side? Miss Kumar.
In fact,
So on the same grounds, his prayer was, huh? SSC, Sarva Shiksha, over.
Sarva Shiksha is a party, but I think, my lord, if your lordship kindly, my lord, have a look.
Yes,
the
Mr. Nayak, you are
responsibility-
there.
Yes, Lordship, I am appearing. My instruction is also there, and I have already furnished the necessary dias code details to the department, Lordship, on the basis of which they have, passed the.
Impugn order was by the director,
Yes. So it has already been considered, Lordship.
considered and rejected.
It was
Rejected.
rejected.
And they said that it is done in compliance with the order disposal order passed by this honorable court. It is absolutely wrong. If I take your lordship to the earlier disposal order.
So it can be taken up for disposal today?
Yes, my lord.
Lordship, I think as the order passed by this court earlier, Lordship, that has already been taken note of, and an order has been passed. This order, present order is under silence right now, Lordship.
Yeah.
So let them file an affidavit, Lordship, how they justify their order, Lordship.
Not
them-
necessary.
let
If your
them file
lordship
it.
kindly, my lord, have a look for a moment.
Hmm.
It is absolutely unwarranted, my lord. If I, so far as from my understanding.
Not necessarily,
Based-
he is not ready to give us, to justify our action also, Lord. So Lordship will give us some time, Lordship.
Lordship
Let
will
us
decide
justify,
if
Lordship.
necessary.
Let us justify.
But let him file an affidavit. Otherwise,
Because this
again,
case has been listed, it was filed long back, my lord, 2025.
huh?
And since then, they have, my lord, rejected
34,
taking the
25.
same stand by violating the
Respondents are
specific
allowed to
direction.
file affidavit.
I'll go with you.
See, now it is more than a year.
Yes. This lady is suffering. In fact, the assistant teacher's post, that post has been provincialized. Whether the act says at least 2 number of teachers post should have been provincialized. And this court has clearly discussed each and
I'll
everything.
look into it because for 1 year you have not filed.
Yes, my lord.
That is not a fair conduct on your part. So let me see.
Yes,
What
ma'am.
is that? Impugn order?
I'll take your lordship to page 42, my lord. Next at 50.
42.
Yes, that was the earlier disposal order.
This was the earlier judgment.
Yes.
Hmm.
The disposal.
Hmm. Hmm.
I'll start from page 43, para 3, bottom. The grievance of the petitioner being sought to be addressed in this petition is adumbrated herein below.
Acha, but let
Yes.
me go through the relevant part.
Yes.
You'll make me read the entire thing.
No, not necessary. The relevant part starts from page 47,
Huh. Yes.
para 8.
Hmm.
It appears from the parawise comments that the time of provincialization of service, the SLSC had considered 3 parameters. Those are name of school in DIAS code for the year, DIAS data for the year 2009 or before. Number 2, name of the teacher in the DIAS data for the year 2011 and afterward. And number 3, enrollment position of the school during 2016-17 and 2017-18. Further, it appears from the record, especially from Annexure 7 of the writ petition, which is the DIAS data for the year, academic year 2009-10 of Pub Amlokhi AS Ahmediya LP School, Nagaon. And in the said data, the name of the petitioner finds at serial number 1 and the name of assistant teacher so-and-so is shown as serial number 2. The year of her joining service is also reflected as 1999.
So you are for, you are one petitioner, right?
Yes,
Jinnatun Nehar.
yes.
So where is her name?
She is Zinnatun Nahar.
Uh-huh.
This is her disposal order, madam, earlier.
Acha, petitioner.
Yeah,
Hmm.
petitioners.
She was the petitioner in this also.
She was the petitioner.
Hmm.
Besides
Okay,
showing
so
that,
what happened? The name of the petitioner was the serial number 1.
yes,
Hmm.
and the name of
She was working as an assistant teacher.
headmistress of the school.
Oh, headmistress. Okay.
Yes, and she had joined earlier, okay, much earlier than the petition number, I mean the other incumbent. Madam.
Hmm. Then?
Then, and the name of assistant teacher so-and-so shown at serial number 2. The year of her joining service is also reflected as 1999, besides showing that she has been working in the said school since 99. Also, it appears from the annexure 8 that the name of the petitioner find mention in the DIAS data for the year 2019-20. It also appears that the enrollment position of the school during the year 2016-17 was 104 and 72 respectively. Thus, it appears that the petitioner has been able to fulfill all the 3 requirements for provincialization of service of the petitioner by the state level scrutiny committee. But despite fulfilling all the requirements, her service was not provincialized. Notably, the documents relied upon by the petitioner is not disputed by the learned standing counsel for the respondent authorities. Besides, no counter affidavit is also filed by any of the respondent. Thus, I find substance in the submission of Mr. Hamad, learned counsel for the petitioner, that despite fulfilling of all the 3 criteria by the petitioner, the respondent authorities had not provincialized the service of the petitioner. Another aspect of the matter that should not lose sight of is the provincialization of service of assistant teacher of the same school, whose name also finds mention in the same DIAS data, annexure 8 for the academic year 2019-20 of so-and-so school, wherein the name of assistant teacher so-and-so is shown at 3rd column. His name also appeared in the annexure 8 along with the name of the petitioner in the DIAS data for the year 2019-20. It also appears that the same enrollment position of the school during the year 2016-17 was 104 and 72 respectively, which was considered in this case, and his case was provincialized, but the petitioner, who had been working as headmistress since 99, has not been provincialized. On such count, the action of the respondent authorities seems to be acquitted by malafides, as because on the basis of same data, service of a person who is junior to the petitioner was provincialized, and the petitioner who has been rendering her service since 99 has not been provincialized. In the result, I find sufficient substance in the submission of Mr. Hamad, learned counsel for the petitioner, and accordingly the same stands accepted. There being merit in this petition, and accordingly the same stands allowed. It is provided that the respondent number 2, it is the director, shall consider the provincialization of service of the petitioner, namely Zinnatun Nahar, headmistress of Puamloki AS Ahmedi LP School, Patrodrava Borbeti Nogao, within a period of 2 months from the date of receipt of the certified copy of this order. This was the Miller director. And thereafter,
And this Abdul Aziz was an assistant teacher, but
Yes.
his service was provincialized.
exactly his service has
But her was left out.
been left out.
She was the
On the
principal.
basis of same report, on the basis of same recommendation by the district level scrutiny committee. That is also a part of this petition. I have annexed.
Hmm.
And thereafter, the violation order, your lordship will find at page 49, annexure 16, the very next page,
Hmm. This is the impugn order.
impugn order.
Hmm.
Page 50 speaks about the decision.
49.
Page 49 starts from page
Hmm.
49, and page 50 is the decision
Hmm.
of the same order. In view of the above, that the name of the petitioner Zinatun Nahar is not available in the DIAS data, New Delhi up to 2012-13, provided by SSA Assam, her service was not recommended by SLSC as well as Joint Committee decision of minors dated 24/7/2020, and hence the claim of the petitioner Zinatun Nahar for provincialization of service as a assistant teacher of Puamloki as Ahmedi LP School is hereby rejected, taking some wrong stand. In fact, I will.
Her name was not found in DIAS data up to 12 and 13.
It is there.
Whereas in the judgment, it is said DIAS data for
Up to
2019.
2019-20, it is there. In fact, I filed one RTI application,
Hmm.
and in response to that RTI application, they have submitted one reply.
Hmm.
That reply also says that my name appeared till 2019-20, right from the 2019.
Prop,
Your lordship, yes, I'll show you.
so apprise me about the DIAS data. I'm not aware. What is this DIAS data?
DIAS data is District Information System for Education.
Mm,
It is a mandatory criteria.
mm.
It is required if somebody's post has to be provincialized, it has to be there right from the year 2009 or before.
2009,
Yes, there is a provision.
when the requirement came into effect.
Yes, if I can, lordship,
Mm,
to the 2017 Act from this book,
mm.
it is there.
Ouch, page.
Yes, page 111.
Mm. Yes.
I'll read the Roman 10 first.
Mm.
Thereafter, I'll go to the Roman 12. Two number of teachers or tutors of the venture LP school shall be provincialized under this act, and their services shall be merged with the base school identified in respect of the area wherein the said venture school was situated. After so merger in the base school, the minimum number of teacher as specified in the schedule of the Right of Children of Free and Compulsory Education Act 2009 shall be followed. The deficit in number of posts of teacher in the base school shall be filled up in accordance with the norms and standards of the said act, and the following the provision of relevant acts and rules in force for filling up of vacant post.
Mm.
It says that at least two numbers of teachers or tutors post shall have to.
But where is that requirement of
Yes,
maintaining data?
yes, that is there.
11, 12.
No, it is there in
Yes, as per
page
DIAS.
107. ZB
107. Yes.
The provision ZB. Venture Law Primary School or Venture LP School means a school imparting education up to class 5 and established by the people of the locality prior to 1/1/2006, whose name figure in the DIAS code up to 2009-10, and prior to that, and whereof the service of the teachers have not been provincialized under any act enacted by the state legislature so far, provided that the DIAS code shall have to be issued on or before 2009-10, and DIAS code issued thereafter shall not be considered for the purpose of provincialization of service of any employee of the institution.
Mm.
It is there.
So here the requirement is that a DIAS code shall have to be issued on or before 2009-10.
Yes.
Huh. And the DIAS code issued thereafter shall not be considered for purpose of such provincialization.
Exactly. madam.
So in a rejection order, it is written that DIAS code was not there in 2009 to 10.
No. In the rejection order, it is said that my name was not reflected in the national, NUPA. It's a record maintained by the National University. There is another provision. That's why I was trying to, yes, page 111. Lordship will kindly go to page 111.
2012 to 13.
Yes, 12 to 13. Roman 12, if I may read.
Mm-hmm.
111, Roman 12.
Mm.
Bottom, the last one.
Mm.
The enrollment shall be verified with the data as per DIAS code 2009-10.
Or before.
Or before as available in the records of the National University of Educational Planning and Administration, New Delhi. They verifies it. There shall be physical verification of students and checking of records of attendance of students of last 3 years.
Yes.
Accordingly, everything was found to be in absolute order. Even then, taking the same stand, and after a specific direction from this honorable court, my claim for provincialization been rejected again, my lord, taking the same stand.
Mm.
Therefore, I was submitting before your lordship that the, response of them in the form of affidavit may not be necessary, my lord.
Mm. Wait, I'll just go through this order.
Yes.
But how her name was not found in DIAS data
It is
up
there.
to 2012 to 13?
I'll take your lordship to the RTI application and the reply, what has been submitted.
Hmm.
Page 40, lordship will kindly have a look
40?
of the writ petition.
40.
40.
Hmm.
This was an RTI application
Hmm.
which was filed by the petitioner before the SPIO.
Hmm.
And in response to this application, they have filed the reply. The next page shows the name of the petitioner, Zinnatun Nahar, Annexure A, page 41. Every fourth line from the second box, name of teachers, Zinnatun Nahar for the year 2009-10. Again, in the next fourth line, Zinnatun Nahar 2011-12. Right from 2009-10 to 2011-12, again 13-14, again 14-15, again 15-16, again 16-17, again 17-18, again 18-19, and the last one is 19-20. So this is their reply. They can't deny it now.
Yes. This is maintained by Delhi.
Delhi, in one way, on the basis of same recommendation, the name of the assistant teacher and his service is provincialized. I have been badly deprived. My name is dropped
His
by the
name was also there throughout, right? Abdul
Yes.
Aziz.
Abdul Aziz.
But
In fact,
was
there
not
a list.
there in 2009.
In fact, a notification was passed. Page 31, Lordship will kindly have a look. Annexure 10.
Hmm.
There was a notification.
Page 40?
Page 31.
31,
Annexure
yeah.
10.
Yes.
Yes, there was a notification whereby for provincialization of services of 3309 tutors against 1698 of venture lower primary schools were prepared. And in that
Wait,
particular
let me
list,
read the notification.
yes,
In persons to the government letter dated
So-and-so,
so and
dated-
accounts with the provisions of so and so. The provincialization of services of so and so teacher against so and so venture lower primary school and demand tutors against demand of against so and so recognized are hereby notified are eligible for
for
provincialization.
provincialization, yes. And in that particular list, if my lord kindly turn to page 33,
Hmm.
33 at serial number 32 in the left hand side. Serial number 32, my lord will kindly come to the right hand side.
Hmm.
Abdul Aziz,
Hmm.
extreme right hand side.
Yes.
My name was dropped.
Drop.
If the recommendation is seen by my lordship, lordship will kindly have a look at page 29. This is the recommendation of the district level scrutiny committee. Page 29, annexure 9. For a moment, lordship will kindly have a look.
Page 29.
Yes, this is the recommendation by the district level scrutiny committee. Noga. Application for provincialization of services of teachers, stroke tutor in lower primary school. In the next page, there is a list.
This is not legible.
In the next page, there is a list, my lord.
Ah.
Page 30.
Hmm.
My name appears at serial number 1,
Hmm.
and that other incumbent, Abdul Aziz, his name also appears, whereas his service has been provincialized. This list
This
was,
is educational and professional qualifications of teachers tutor.
yes, everything. This is the part of recommendation by the
Hmm.
district level scrutiny committee. It was
Part
counter.
of recommendation by the district level.
Yes. My name is at serial number 1. Even then, they did not consider
Just
it.
take me to the High Court's order again once more.
Yes.
At page 42, right? 43.
Yes. 40.
Hmm.
Start.
Okay, so yes, Mr. Nayak, what is your reply to this? Her name appears in the Dias data of 2012-13, but it is said it had not appeared, and so it was her claim was not adhered to.
Lordship may kindly see the last order passed by this honorable court. If Lordship comes to page,
In this case,
no, earlier case, Lordship, prior to passing of the speaking order,
hmm,
at page 48.
hmm, yes. Hmm.
So in spite of observing so many things, Lordship, what the honorable court held in paragraph 15, Lordship,
Hmm.
it is provided that the respondent number 2 shall consider the provincialization of service of the petitioner, namely Jinnatur Nehar. Lordship, may kindly see the name. Name, I mean the spelling.
Oh, Jinnatun Nehar. Oh. Yes. Same.
Administrators of Poop Amloki AS Ahmadiyya LP School,
Hmm.
Batadrova Behar so and so, within a period of 2 months from the date of receipt of the certified copy of this order.
Hmm.
So a particular name is there with particular spelling, Lordship.
Hmm.
Now, if Lordship comes to the Dias data, Lordship, this is the copy of the Dias data, Lordship. Here one Jinnatur Nehar is there, but her name is JINN.
So you are disputing the name, but then that was not the reason for your rejection?
Lordship may come to the speaking order.
Acha, page number of that.
49.
49 is the impugn order.
Yes.
That is
Same.
dead.
If Lordship comes to the bottom of portion, Lordship, last paragraph in page 49. Accordingly, SSA Assam furnished Dias data in respect of all proposals as received from concerned DEOs for provincialization of service as per Provincialization of Service Act 2007 SLSC, scrutinized all proposals and found that as per records furnished by SSA Assam, the name of the petitioner Jinnatur, spelling Lordship may kindly note. Jinnatur Nehar of Poob Amloki AS Ahmadiyya LP School does not appear in Dias data of NUPA. Remaining portion is not legible, Lordship.
2012-13.
Yes.
Hence, SLNC as well as so-and-so recommended only the
Name of
service of.
Hindulogist.
Hmm.
So that is the reason, Lordship. Authority considered in terms of the court's order. In the writ petition, name of the petitioner is ZIN and Jinnatur.
I mean, show that what RTI reply where it
Yes.
is seen. Where is that?
Page 40 and the next page, page 40. 40.
40.
Yes, this is a mistake that had occurred on the part of the authorities. And for that.
No, some Jinnatun, that is Z only. Jinnatun
only.
Nehar.
That-
Only in 2009-10 it was J.
Yes, it was
But rest 9-10,
all are Z.
10-11, 11-12, it is Z.
The requirement is 2009-10.
And this was a part of earlier also, my lord, this was a part of
If
writ
Lordship
petition.
comes to the
This was
provision,
never disputed by them.
2ZA.
Mr. Nayak, this is your
That's
submission.
J, my lord.
Lordship.
This is your submission to defend the order.
Yes.
This was not the reason for rejection.
Exactly.
That is the reason for it.
But that is not mentioned. The one that is there is
That's
another
the
one.
mention, Lord. Lordship may kindly see who filed the writ petition, ZI.
Hmm.
Who in whose order was passed in respect of the petitioner one Jedi. Consideration was in respect of one Jedi. And Jedi name was not there in the Dias data.
Jedi name was there, but
Not there.
in 2009-10 it was
Lordship, we are
JI.
concerned with 9-10 only.
But then in your impugn order it is written 12 and 13.
Yes.
No,
Is not available in Dias data up to 12-13.
yes, Lordship may kindly say up to 12-13 the name is JI. Thereafter, Lordship, it is ZI.
I'll
No, you
clarify.
cannot
But school
blame the
is
same
also
for
same.
every.
My
Lordship.
lord, school is same, incumbent is same, everything is same. And in fact, my lord, on the earlier round of litigation, my lord, this was never disputed by any of the authorities, my lord. And in fact, just to rectify their mistake, my lord, I filed one application. That is also a part of
So my
litigation.
friend is saying
take it
he has
Lordship,
no
page-
responsibility so far as
page
his
36.
her name is concerned.
Page
In the
36.
Dias data, it is clearly JI. Up to 2012-13, it is JI. Thereafter, it is ZI.
My lord, it is their mistake which has been
rectified that
rectified there.
mistake?
And that was not the
I
case
can-
anywhere.
That is the ground in the speaking order, Lordship.
No.
Jedi's name is not there till 2012-13.
That has not
That
been
is the
mentioned in the impugn
specific.
order, my lord.
Either you speak or let me speak.
Okay, let him
My
complete.
lord.
Jedi.
So Jedi is not there. That has been simply narrated in the speaking order.
Hmm. But see the findings there in the initial paragraph. Petitioner Jinnatu Nehar was appointed as assistant teacher under so-and-so in 1999. There, the authority has accepted petitioner as Z. She was appointed in 99. Right. All throughout the case was of ZI.
Yes, direction was in respect of one Jedi. And it was for the authority to consider. Authority considered simply. So that is why I'm saying, Lordship, let the authority file one affidavit. Let him
Lord-
object that Jedi and JI is the same person.
Page 30 will clarify, my
Then
lord.
all
This
ultimately
is the
Lordship
list,
will
my lord,
decide.
prepared by the, my lord, district scrutiny committee. Again, my lord, I'll take a lordship. Whether my name
But
was
again,
page
the
30.
name of the petitioner Zinnatun was recommended by DSC for provincialization.
Yes,
There Z.
Z.
Yes.
And the date of appointment was
And
also
it's the
shown as
same person, JZ
15/3 to 1999. My lord will kindly have a look at page 30 again.
30.
Yes.
Hmm. Yes.
The serial number 1, Z is mentioned, not J. And this is a list prepared by the district scrutiny committee, my lord. In the right hand side, date of joining has been mentioned as 15/3/99. I joined to the service.
And this is Z. You see page 30. This
Yes.
is Z.
Yes, it was Z.
And so that Z and J
And in fact, in
seems to be the same person.
same person, in fact, in the impugn order, nothing has been mentioned that whether my name was earlier J and thereafter it was rectified as Z. Nothing has been mentioned. They can't take this kind of stand right now, my lord. And this court has already clarified that the petitioner is Zinnatun Nahar, whether it is written as J or Z, doesn't matter. Nothing has been discussed. This was never disputed, my lord. This is the second round of
This cannot be
litigation, my
said
lord.
that one with J is another person
Lordship,
working in the same
my-
school.
I don't know what is his understanding or what is the understanding of your Lordship. But my simple understanding, authorities say till 12-13, Jedi was not there. JI was there, definitely Jedi was there. And that is the finding, that is
An implication. The authority had not clearly said that
Yes.
the one who is there was Zedai. And so the petitioner was not there.
Yes.
Those things at least has to be there. Like now you're taking that stand. And during the writ proceedings also, there was nothing
Nothing.
of ZZ.
ultimately, Lordship Court directed the authority to decide, consider and decide. Authority considered, and simple ground of the authority is there. Up to 12-13, Jedi was not there. That is the ground. You clarify, go and clarify before the authority that JI and Jedi is the same
authority-
person.
Has never said it was Zedi or Jedi.
Authority said
Has never said anything.
12-13, Jedi
Be
was.
in the earlier impugn order or the, my lord, the violation of this High Court's order, my lord.
And in the this one, in the recommendation also,
Technical discipline.
recommendation it was ZI only.
Yes. And in fact, I submitted one application also, long back, my lord. Annexure 12, my lord, page 36, my lord. Regarding this J and Z,
Where? What
page
have you-
36, my lord. Annexure 12, my lord. Was filed on
Oh,
17.
that was an issue before also.
Not before,
36.
since my name was wrongly, my lord, shown, the spelling was wrongly shown in the dais, for which I submitted one application before the district elementary officer, my lord.
This was when?
This was
21.
17/2/2021.
So what happened after this letter?
After this letter, my name was, well, I mean, rightly, and prior to submission of this letter, this application, they have rectified my name, as I have shown at page 41, my lord. The spelling only is Z and J. They have rectified it, my lord, in the servo section, my lord, portal, my lord, page 41.
And in reply to your RTI also, it was to J.
J.
Vinnatul Nehar.
Yes. I cannot upload it in the portal, my lord. In the J or Z is not the different person.
See
They have
page
never
number,
said.
see page number 38. It was J again.
This has been written by the SPIO.
But then the headmistress of this school, that
Yes.
school, will be one person.
One person.
And
sir.
this is Jinnatu.
The lordship.
I
the
submitted one
problem is-
application in
Problem
Assam.
is, lordship, these documents, lordship, we cannot rectify. This has to be rectified at Delhi. We have no, I cannot open the computer also. I cannot log in, so I cannot rectify the spelling of the name of the petitioner. So what is there, it is there. You will have to apply before the appropriate authority, get corrected, get this list corrected. Only thereafter we can consider his name.
Milord,
Unless lordship passes an order or direct the
it
authority.
is already
that A and
rectified.
Z are same person.
It is already rectified. Therefore, the
Not
question of
rectified.
rectification
In the
is,
dais that
that
I
may not arise right now, my lord.
In the dais that
Already
it is not
rectified.
rectified. You officially, whatever rectification you want to do,
As your
you can-
lordship has already seen,
this will be rectified only at
it
Delhi.
is already rectified, my lord. And I cannot do anything, my lord. This is beyond my capacity, my lord. And they have never said that this is, and even this court on earlier occasion also has never said that this Z or J is the different person or having two separate identities, my lord. She is the headmistress of the school, my lord. This J was rectified by the Sarva Shiksha authority.
And
later.
this point was not raised before the earlier proceeding, right?
Yes, right.
In the earlier proceeding, what had you challenged?
The same, my lord, findings, my lord. They, whatever they have given in the findings of
No,
Yes,
earlier
sir.
proceeding, what was the subject matter? What
state
was
level
challenged?
scrutiny committee did not consider my case for provincialization because of the three grounds, three parameters. That has been mentioned at page 39. They took another two stands. Page 39, not having Newport Dias Code of the school for the year
No, that
2009.
name part was not there.
Name was not there. They said that not having Newport Dias Code to school for the year 2019. This
Yes,
was
it
the
was
first
not
ground.
there. Because it
Or
is
prior to
not-
that, as per clause 3,
Mhm.
within bracket 3 of the 2000 Act 17. Mismatch of the name of the school with Dias Code. Not my name. Mismatch of the name of the school.
Where are you reading?
Page 39.
29.
Not the incumbent's name.
Hmm. This was put to challenge in the earlier round.
Yes,
Hmm?
yes,
Annexure A.
yes, annexure, yes. And this has been rightly discussed in the earlier writ petitions disposal order, my lord.
Not discussed, no, if it was.
Rightly discussed.
Acha, let her file an affidavit bringing into record this aspect.
My lord, this aspect is not going to change the nature and
It
character.
may
of
not
my case,
change, but let her file, then we can discuss the entire
They
text.
have nothing to submit, my lord, and this is a mere technicality. This was never disputed by any of the respondent authorities on earlier round of litigation, my lord. And now they are finding a different, my lord, taking a different stand that because of J and Z, my service could not be provincialized, my lord.
So in the earlier round, it was only for your provincialization.
Exactly.
Office
Now
service.
also, my lord, same.
And then no such cancellation of any order and all, like it is done in the present
Yes.
case. It was for only provincialization.
It was only for provincialization.
And in that proceeding, this point was not raised, that it was a different Jinnah tool till 2012-13. And after that, it is
Even
a
they
different
cannot,
Jinnah tool.
because in the Sarva Shiksha, my lord, website, in the portal, they have rectified. Whatever the mistake occurred on the part of the authority, that has been rectified by them.
Where rectified?
Page 41. Page 41.
Huh, 41?
Yes.
No, that is, but then the names remained as such in the earlier academic years.
As
Right.
such, they have rectified for the later years, madam. But it should have been rectified right from the very beginning. They have not done it. This is their list. I cannot do anything. It should have been done right from the 2009-10. But whatever has been done by the respondent authorities, they have done it right from the 2013.
No, this is the same person, Mr.
Same
Naik.
person.
I'll
Hold on.
take a break for 2 minutes and I'll dictate the order. Heard Mr. Jed Hamad, learned counsel for the petitioner, and Mr. P.S. Nayak, learned standing government advocate.
I'm P. Nair. I'm appearing for SSA Lordship.
P. Nayak, learned standing counsel for SSC. Ms. S. Kumar, learned standing counsel for secondary education. Elementary, I always get confused who is in the elementary education. By this application, preferred under Article 226 of the Constitution of India, the petitioner has prayed for setting aside of the impugn order dated 5/12/2024 passed by the Director Elementary Education Assam, by which the petitioner was not considered for provincializing her services. Stop. The case of the the case of the petitioner is that she was appointed as an assistant teacher of Poob Amlokhi A.S. Ahmedia LP School. By order dated 15/3/1999 and by a subsequent order dated 1/3/2000, the petitioner was appointed as the headmistress of the said school. Of the said school, vide resolution number 1, owing to the leaving of the said post voluntarily by the earlier headmistress. Thereafter, on 12/5/2005, the SI of
Sub-Inspector of Schools, SI of Schools.
Sub-Inspector of Schools, Batradhava Circle, Nagaon, prepared an inspection report and reflected the name of the petitioner therein as headmistress, along with 3 other teachers. And in the said school, it was found that there were 107 numbers of students, and the infrastructures were also found to be intact. However, the petitioner's services was not regularized in spite of her eligibility for the same, and aggrieved thereby, the petitioner had filed a writ petition being WPC number 3854 of 2022. And this court, by order dated 30/9/2024, had held that the petitioner's name finds place. No. Where is the finding in that judgment?
Yes,
Paragraph 9.
paragraph, starts from paragraph 9.
Held that it appears from it appears from the record, specially Iman 9 of Iman and near 2. Held that in the DISE data, data for the academic year 2009 to 10, Apub Amlokhi AS Ahmedia LP School, Nagaon, petitioner's name finds place at serial number 1. But where is that serial number 1? She was at serial number 4. DIS data of 2009-10, right?
Yes, 9, 10. Page 26 again. Take a look. Annexure 7, page 26. Left hand side, serial number 1.
This is also DIS data.
DIS data. First DIS data, 2019.
Okay. Was finds place at serial number 1.
Yes.
And that the petitioner was working in the said school since 1999. And also that her name appears in the DIS data for the year 2019 to 20. And further, the enrollment position of the said school during the year 2016 to 17 was found to be 104 and 72 respectively.
Yes.
Full stop. It was further held in the said judgment and order that petitioner is required to fulfill 3 requirements for provincialization of service, and that she has fulfilled the said requirements. And as such, it was ordered that the respondent number 2 shall consider the provincialization of the petitioner, namely Jinnatun, Z लिखिबा, हाँ, ZINNATUN, Jinnatun Nehar, NEHAR, headmistress of the said school, within a period of 2 months from the receipt of the certified copy of the said order. In pursuance to the said order, the Director of Elementary Education, Assam, passed an order on 5th of December 2024 holding inter alia that the petitioner's name did not find place in the DIS data till 2012 to 13 provided by SSA Assam, and as such her services was not directed to be provincialized, and the prayer of the petitioner was as such rejected by the said order. The learned counsel for the petitioner submits that the petitioner was appointed in the year 1999 as an assistant teacher and thereafter was promoted to the, not promoted, right? But thereafter was appointed to the post of headmistress in the year 2000. And that in the recommendation, this is recommendation for what? Provincialization, right?
Yes, yes, my lord.
But this is application for provincialization of services.
This is the prescribed pro forma. This is how they sent it. The district level scrutiny committee.
In the recommendation for services, for provincialization of services of the teacher slash tutor in the lower primary school, the petitioner was shown as number 1 in the said list. Full stop. However, he submits that on 4th of February 2021, right? 2021,
Yes.
a notification was issued where by which number of tutors were directed, a number of tutors were mentioned in the said list whose services were eligible for provincialization. And in the said list, that was for tutors. She is a headmistress. Perhaps because of that, her name is
No,
there.
no, tutor. She's also a tutor.
She was also a tutor in 21,
Tutor, yes.
but she was headmistress in 2000.
Tutor. The post is tutor. She's higher secondary. She's tutor. The tutor, definition of tutor.
See your pleadings.
Headmistress, but the post, when the post is provincialized, it is written as tutor. In fact, the assistant teacher, my lord, the recommendation shows that the other incumbent was shown as assistant
As
teacher.
a tutor.
Yes.
কি করলো? And in the said list, the name of the petitioner did not figure. What is this annexure 11?
Annexure 11 is a communication made by the block elementary officer to the district.
Thereafter, he submits that the block elementary education officer, Batradhava Nagaon, Assam, by a communication to the DEEO Nagaon, District Elementary Education Nagaon, had forwarded the application received from the petitioner for provincialization offer service.
Her name was dropped, man. As such, again it was forwarded by the block officer.
What is due to dropped on?
This is his language, my lord. Meaning thereby her name was dropped, my lord, on earlier occasion. Again, a fresh proposal was sent
It's
by.
okay, her representation was forwarded.
Yes.
And what was the occasion for you to write this letter that you are not Zinnatul but Jinnatul?
That was on 17/2/2021.
Why did you write this? The issue had cropped up, that means.
Page 37.
The issue had, that means, cropped up.
Not
Regarding
cropped up.
your mistake.
I was informed by the block officer that my name was wrongly uploaded in the website.
Any pleading to that?
No, I have not mentioned. It was only mentioned merely. As such, I
Okay,
filed.
full stop. Mr. Hamad, Learned Counsel submits that the petitioner was informed that her case could not be considered because her name was wrongly reflected in the said DIAS data. In the DIAS data. That is, in place of Z, Zinnatul Nehar, it was reflected as J, Jinnatul Nehar. And in view of the said information, the petitioner made an application to the District Elementary Education Officer, Nagaon, that the said mistake was inadvertently made and was wrongly reflected, not inadvertently, was wrongly reflected. And a request was made to verify that Zinnatul and Jinnatul, Z and J, are one and the same person. And the verification was by way of to verifiably disclose upon department to verifiably kolna by way of checking the documents Validia. By way of checking the documents in order to find out whether one and the same person, right? The learned counsel also submits that he had filed submitted an application before the State Public Information Officer to furnish her, so Michael, lady, to furnish her with the DIAS data maintained by what, Delhi?
Maintained by Sarva Shiksha Abhiyan Assam, SSA Assam.
But some Delhi.
NEUPA, NEUPA, all capital, NEUPA, NEUPA.
NEUPA? L.
Not L, A for apple.
A.
Yes.
NEUPA, Delhi. This is maintained by the Delhi part.
This is already, my lord, this has been maintained by the Sarva Shiksha Authority in Assam. And for provincialization of services, they said it before the NEUPA, Delhi.
Acha, maintained by the SSA Assam.
Yes.
And in pursuance to the said application, the list was provided. Wherein the petitioner appears in the DIAS data since the year 2009-10 to 19 and 20. As such, he submits that there was no impediment for provincializing the services of the petitioner. And he also states that the judgment and order passed by this court on 30/9/2024 also makes the entire aspect clear. However, he submits that the respondent authorities had rejected the claim of the petitioner for provincialization on regions best known to the said authority. On the other hand, Mr. P. Nayak, learned counsel for SSA, right? Sarva Shiksha Abhiyan.
Yes.
SSA submits that the authorities have examined the case.
I'm formulating. My first submission is DIAS list is, it is made on the basis of a list forwarded by the concerned school. Names are not, spellings are not my creation. These are forwarded by the concerned school, and on the basis of the list forwarded by the concerned school, names are included in the DIAS data.
Wait, the DIAS list is made on the recommendation by the school.
Yeah, no,
on the information given by the school.
they prepared the list.
Mm.
It is forwarded to the SSA lordship. Accordingly, SSA includes the name of the concerned teachers in the DIS data for a particular year lordship.
The school provides the information,
Yes,
provides the list,
yes, that is one.
and the authorities prepare the DIS
On the
data.
basis of the list forwarded by the school,
Mm.
authority, SSA authority, inserts the name of the concerned teachers. That is
Mm.
one. And this is kept open for the SSA authority for 1 year only. Once it is locked, we cannot correct or rectify the list any further. It
For
is,
1 year.
we can do it for 1 year only.
After 1 year, you cannot
After
reach.
1 year, it is NUPA, lordship.
Acha.
Only they can rectify.
Mm. Mm.
In 2012-13 lordship, so up to 2010-11, her name was forwarded as JI.
Mm.
Thereafter, lordship, her name was, I cannot say that both are same person.
Mm.
Thereafter, lordship, one Zedai's name was forwarded. Accordingly, it was inserted as Zedai.
Mm.
So that is the first submission.
Mm.
Now,
Okay,
if lordship
okay,
comes
you're
to
right, Mr. P. Nayak. The Learned Council for SSA submits that the list of teachers to be included in the DIS data is forwarded by the school. কি বুলি ক'লো প্ৰথমতে? Is forwarded by the school, and the SSA on the said list prepares the DIS data, and the same is kept for 1 year for any rectification. And after a period of 1 year, the SSA has no authority to rectify, and if any rectification is to be made, the same can be made by NUPA Delhi.
Yes. Second,
He as such submits that the school has forwarded the name of the petitioner. No. The school has forwarded the headmistress of the school as as Jinatul for the years 2009 to 2012. And thereafter, the school has forwarded the name of the headmistress as Jinnatul, Jinnatul for the subsequent years. And the list was accordingly made by the SSA and had shown that in the DIS data. Then,
lordship, at page 37, this was the application made by her decision vernacular in 2021 for correction of her name in the DIS data, lordship. But lordship may kindly say this was forwarded to the district education officer,
Not-
lordship.
it was made to district elementary.
Yes, but it was not made to the concerned authority, that is NUPA, NUPA. So only, as I have submitted, only they can correct or rectify. DE was not the appropriate authority to rectify the DIS data. And secondly, lordship, whether it was corrected or not, that is also not clear, because it was in 2021, but her name was, one Jinnatur was already there from 12-13. So
Yes.
that is this application was not made to the appropriate authority. And secondly, lordship, it is not clear whether her name was, any decision was taken or not.
Because
That-
by 21, her name is Jed only. Till 12-13, it was J.
Yes.
But the school college certificate says, which was issued long back, Z. Absolutely. This is her certificate.
Okay, I'll come to that. Let him finish. Then,
Look,
This-
for authority lordship, it was only the three conditions.
yes.
DIS data, and the main condition was DIS data on or before 2009-10. And if lordship, whatever list he has furnished, lordship, it was the document furnished by the petitioner himself, that up to 12-13, there was no JEDI, lordship, only JI.
That document also shows J.
Subsequently,
That document also shows J. It was J only.
there are from 12-13.
From 12-13, it is Z.
We are not concerned with 12-13.
Mm.
We are concerned with 9-10.
9-10.
What was the name recorded up to 9-10?
Mm.
That was our concern, and on the basis of that only we take a decision. And if Lordship comes to the judgment passed by the learned court earlier, Lordship may kindly see
Acha,
submission.
Mr. Nayak further submits that the petitioner and that the petitioner had written a letter to the district elementary education officer Nagaon for correcting her name in the earlier in the Dias code of earlier years, and that he submits two grounds, that he submits 2 points with regard to the same. First, the said application was not to the NUPA Delhi, who can rectify the said names. And second, the necessary rectification was not done in view of the said letter.
Done or not, that is not confirmed from the records, Lordship. I'm
It
saying
was
a-
done
a-
only.
application was done, application was there, but as is, appearing from the recent record, it had, no correction has been made. In fact, he was not the authority, he cannot do any correction also. Thirdly, if
There-
Lordship comes to page 44, Lordship.
Hmm.
Page 44 is the judgment, earlier judgment.
Hmm.
Lordship, in the middle portion, Lordship will get one line. It is the contention of the petitioner.
First paragraph.
First paragraph, page 44, first paragraph. In the middle portion, 107 is there.
Hmm.
Next line, Lordship.
It is the contention.
It is the
yes.
contention of the petitioner that her name finds mentioned in the Dice Code for the year 2009-10, having code of so and so. Therefore, her name also finds mention in the year 2010 and thereafter so and so, so and so. So it is nowhere it is mentioned that my name was earlier JI, now it is ZI. So that dispute, that fact was suppressed by the petitioner. that
Not
Z-
raised by you also.
Yes, this was never disputed by the authority.
Not raised by you.
They have missed out. They have filed the earlier, my lord, response to the, my lord,
Yes, where? Show me where you have raised this. You have not raised. The government advocate has not said anything
Government
during
only
that
said-
proceeding.
Government only said that her name was not there prior to 2012.
You could have, before the court, like now you are saying me,
No.
you should have placed it before that court.
No, we are only concerned with, at that point of time, we are only concerned with ZI. And if Lordship comes to page 46, Lordship,
Hmm.
if Lordship comes to paragraph 5.1,
Hmm.
clear line was there, Lordship, Jinnatun Nehar of, in the middle portion, Lordship, 5.1. Nehar of Poob Abloki so and Nagaon does not appear in Dias data of NUPA New Delhi up to 2012-13.
Hmm.
Whatever may be reason, J and ZI and ZI,
This is
ZI's name was not
vague.
there.
You should have clarified, you should have said in clear terms that it was actually J and not Z. And that is why we are saying her name was not there.
What would have been clearly lied or what submission could have been made at that point of time? These are different issues. But apparently a position was taken that ZI's name was not there up to 12-13. That is what exactly reflected in the speaking order. That ZI's name is not there was not there, is not there in the list till 2000.
It's okay. What else are your submissions?
These are my submissions on today.
And Mr. Nayak further submits that in the previous proceedings before this court, a contention was made that the petitioner's name did not find place in the Dias data of 2009-10. Dias data, কি কলো data of NU DIAS data of NUEPA New Delhi up to 2012 and 13. And he further submits that the impugn order dated 5th of December 2024 was passed after considering the order dated 30/9/2024 passed by this court, and on finding that the name appearing in the DIAS data for the year 2009 to 2012 is not of the petitioners, and it is of one Zinnatun Nehar J. Jinnatun Nehar, and that the petitioner's name only finds place after 2012-13. After 2013-14. Yeah, 2013-14. And as such, he submits that the order passed on 5th of December 2024, impugned in the instant petition, is a correct order, and there is nothing to interfere with the same.
Just one line, Lordship. The issue that JI and JDA is the same person, that issue has never been raised or adjudicated by this honorable court. So that is issue.
That's
It
what
will be
I said,
decided
that
on. Yes,
it was
please.
never raised.
Yeah.
It's okay, enough. Heard the learned counsel and have produced the records.
No, Lordship, what I'm saying, that both the names are of the same person, Lordship. That issue has not yet been decided. That is what I'm saying.
That has been never
But I'm
been decided,
submitting
never
that
been
that
raised.
issue was never raised by the
Only
respondent.
one letter by him
In
correcting
fact,
his
it is
names.
admitted position of the case that both these names
Not
appears to be the
adjudicated,
same in one
adjudicated.
person.
Nowhere that has been
My lord,
adjudicated or adjudicated, not
this
decided.
disposal order, my lord,
That is
will
what I'm
speak, my
saying.
lord. They have never disputed, my lord, in the earlier round of litigation.
Disputed or not, that is a different
Not,
issue.
nothing, my
But
lord.
inner
It,
and
um,
that Lordship are not
It
decided.
is provided under the rules that provincialization of service requires 3 conditions to be fulfilled. Number 1, name of the school in DIAS data for the year 2009. Number 2, name of teachers in DIAS data for the year 2011 and afterward. This is, where is the rule providing these? 2017 Act.
17 Act, and they have set a parameter, my lord.
No, তাতকৈ তুমি দিয়া
Page 39.
peruse the records of পিছতে দিয়া that as was observed by this court in the judgment and order dated 30/9/2024, that SLSC had considered 3 parameters for provincialization of services of the teachers. And they are related here. 1, name of the school in DIAS data for the year 2009. Name of 2, name of teacher in the DIAS data for the year 2011 and afterward. And enrollment position of the school during 2016-17 and 17-18. It was also reflected in the said order that the name of the petitioner found place at serial number 1 in the DIAS data for the academic year 2009 to 10. Full stop. The year of joining service was also reflected as 1999. Further, it was also found that the petitioner's name finds place in DIAS data for the year 2019-20. And as far as the enrollment position is concerned, it was found for the year 2016-17 as 104 and 72 respectively. Full stop. As such, this court had held that the petitioner had fulfilled all the three conditions for provincialization of her service by the state level scrutiny committee. The argument raised by Mr. Nayak that the name Zinnatul J and the petitioner, which is Jinnatul Jed, is not of the same person, which according to him was never an issue at any earlier point of time. Is also cannot be held to be correct in view of other particulars mentioned in the data, inasmuch as in the year 2009 and 10, the name of the petitioner no. In the year 2009 and 10, the DIAS data reflected. Where is that DIAS data? Hold on.
Page 41,
Reflected against Zinnatul J. Jinnatun. It is all N, D, L নহয়, মই Jinnatul ভাবিছো, huh? You make it N. Zinnatul Nehar. The school shown was Pub Amlokhi A.S. Ahmedia LP School. And the code, and the what code? DIAS code was mentioned as 181-001-001-15. Hey, 0000 দুবাৰ আছে. 105. And the place is mentioned as Batadrava.
Yes.
Batradrava. Batadrava. And for this and for the years where the name is reflected as Jed Jinnatun, Jed INNATUN, Nehar, the same school is reflected with the same DIAS code and for the same place. And after 2013-14, the name referred in the DIAS code is Jinnatun, Jed. Jinnatun Nehar. As such, it cannot be disputed that Jinnatun J, Zinnatun Nehar, and Jinnatun Nehar and Jed-in are two different persons. Further, full stop, huh? Further, the said argument was not raised before the earlier proceeding, which culminated in the order dated 30/9/2024, and in which the petitioner was stated to be eligible for provincialization of her service. In the impugn order dated 5th of December 2024, it was simply written that petitioner's name did not find place in the Dias data up to 2012 and 13. Without further clarifying that the petitioner without further clarifying that the name written against the said Dias code, name written in for the year 2009 and 10 till 2012 and 13 as Zinnatul is a different person. Acha, okay. Acha, I might forget. Prothom lainote diba যে opportunity was given to the state respondents to file affidavit, but more than 1 year had elapsed and they had not filed their affidavit, and as such, this case is taken for disposal without their affidavits.
I think this is only the second time this matter got listed.
But 1.5 years has gone by. May, that was in second time, third time what? It is a rule or what? Second time and first time not required, second time, third time it is required. What is this contention? Don't make such arguments before me. No, I'm disposing of. Now you were allowed to file your affidavit in 34/25. Now we are in a month of May gone. So I'm writing this, I'm without it. And then what is this first time? Okay, then, okay, keep a question. Hey, to line likhi diba, ha, prothom. So, keep a go last one. Is a different person. Seeing the number, the Dias number, as well as the school, as well as the place, it is beyond reasonable, it is beyond any iota of doubt that the name reflected as Jinnatun Nehar and Zinnatun Nehar belongs to one and the same person. And as such, the reason for rejecting the prayer of the petitioner, that rejecting the prayer of the petitioner for provincializing her service is found to be wrong in the considered opinion of this court. More so, in view of the fact that the name of the petitioner finds place in the Dias data since 2009 and 10.
Right.
As such, the respondents, who will do the regulation? The director.
The director, respondent number 2.
As such, respondent number 2, the director of elementary education Assam. Actually, in the last order, it should not have been considered. It should have been direct.
Directed, yes.
This consideration is as the Director of Elementary Education Assam is directed to provincialize the service of the petitioner. Forthwith, not
Yes.
from a back date.
Yes.
Forthwith, if not found ineligible on other grounds.
Yes.
If not found ineligible on other grounds, petition is disposed of.
My lord, within a period of.
Acha, acha. Within a period of, likhi diya? Within a period of 1 month from the date of receipt of this order.
My lord.
Petitioner is further directed to place the certified copy of the order before the before the concerned authority at the earliest.
My lord. I'm deeply obliged.
Petition is disposed of.
High level.
Yes, Mr. Bhuya.
Uh, may I please, your lordship, my lord, in this case also no affidavit till date, my lord. A speaking order is under challenge, my lord, so affidavit is required.
Mm.
My lord, I think it is the second time it has been listed.
No, first time, I think.
Uh,
This was also July 25.
My lord, my lord. My lord, the issue is that we are, my lord, the education volunteers appointed under.
No, there was no time taken for filing affidavit, I think.
My lord, my lord,
Notice is complete, furnish extra copies,
my lord.
list again.
Yes.
So, affidavit is required?
Will be done.
Nayak Pathar.
Yes.
Fukon?
Yes, sir. We'll be filing, madam. We are waiting our instruction.
You are for the
For the elementary education.
elementary education, you'll file it. Yes, Mr. Bhuya?
My lord, because the issues are some consideration is required without pleading, it will be difficult, my lord.
Heard Mr. Bhuya?
My lord.
Yes, learned senior counsel assisted by Mr. Alav.
15.
No, you are, oh, there are two matters.
Matters, my lord. In item 15, my.
16, Mr. Bhuya, you are in 16.
I am in 16, my lord.
15 also no affidavit.
No,
16 also.
First, second time, madam. So we'll file a affidavit.
Yes, you had not taken time before.
Exactly.
Okay, 15 you write, heard Mr. H. Ali, learned counsel for the petitioner, and Mr. A. Fukon, learned, standing counsel for elementary education. Mr. P. Nayak, you are for?
SSA.
Uh-huh.
SSA.
SS. P. Nayak to Agod diba, huh? Mr. P. Nayak for SSA, Mr. A. Fukon for elementary education. Okay, we'll represent all the parties, right? Mr. A. Fukon, learned counsel. Mr. Nayak, you'll also file affidavit.
Yes, ma'am. One affidavit.
Mr. Nayak and Mr. A. Fukon submits that they will file the affidavit in the instant petition and has prayed for some time. Prayer is allowed. List this matter on 10th of June.
my lord.
Will be very late.
Lordship, let it come after vacation, Lord. After vacation.
After vacation, no, July vacation.
My lord.
Now this prayer is yet to be made. After 1 month, this prayer can be made. So on 10th of or 15th of June,
15th of June, my lord, it will be.
15th of June,
My lord.
2026. It will likhiba it. 16th likhiba, heard Mr. A.R. Bhuya, learned senior counsel, assisted by Miss
Laskar, my lord.
Miss
S.
S. Datta.
Laskar, my lord.
Oh, S. Laskar, learned counsel for the petitioner, and Mr. P. Nayak, as well as it will they will file affidavit. Huh?
Right.
List this both this matter on 15th of June.
Obliged.
Mr. Bora.
This case, my lord, notice was issued on 25/7/2025, matter related
Why
to.
these matters are coming up so late?
Pardon?
Why these matters are coming up so late?
Don't know, my lord, not,
And the matter was fixed up after 4 weeks.
my lord,
That is why we have an instruction to fix matters on fixed date.
my lord.
Because after 4 weeks, there is no date and it is somewhere in between the files.
Regarding my lord, pension as well as
Huh.
area, so.
Pension.
Pension as well as area. And,
Now it is for more than 1 year. He has not got.
And on the other hand, the specific direction was given by the honorable court, but they did not contempt this is also.
But I think their response will be required.
Yes, my response is required.
My lord, here I have received.
You have not taken time before.
No, my lord. I have received the instruction, my lord. 3 weeks time may be granted. I will file it.
Received the instructions of 2 weeks. Pension. So like, it's a question of livelihood.
The instruction is.
But he
received
will,
and
he,
maybe
it
my
access a
lord,
point.
before the-
Okay, by that instructions, it can be disposed of.
Let us file an affidavit, my lord.
Placed before your lord.
Let us file our affidavit, my lord. She is not entitled to, entitled for a
Where is
venture.
it?
On the basis of my instruction, I am submitting.
Okay, let him file affidavit. Heard Mr. Didia, who is appearing for other respondents?
Finance is there. my lord.
Only you are representing all.
No, my lord, their respondent number 6 is finance, my lord.
Then they will again say they will file affidavit, so they get them. Heard Mr. N. Bora, learned counsel for the petitioner, and Mr.
PK Bora,
P.K. Bora, learned standing counsel for
elementary,
elementary education, representing respondent number
1 to 5, my lord.
1 to 5. Finance, Mr. Chaliha.
My lord, yes,
Okay. 1 to 5. And Mr. A. Chaliha, learned standing counsel for finance,
finance.
finance department. Mr. Bora, A.K. Bora,
PK.
P.K. Bora, learned counsel submits that the department requires some time to file their affidavit. Although he has the instructions with him and has prayed for some time, prayer is allowed. List this matter on 8th of June. You already have instructions, you just have to incorporate.
Well, 8th of June.
Pension, no? 8th of June.
8th of June.
8th of June,
Ma'am.
2026.
God bless.
March.
There in this case, I need some time to file affidavit, my lord.
You were already granted 3 weeks time, as Bhuya was there.
My friend was there.
Last two occasions, they have sought
Oh, yes, Mr. Bhuya.
filed their affidavit.
Instruction has been received, my lord. I'll file affidavit.
Here also, lethargic.
Last opportunity may be given, Lordship.
In the month of February, you had taken time. In the month of March, you had taken time. Okay. Okay, 2 weeks time only.
Lordship, kindly fix a date.
Heard Mr.
Sicolita.
C. Kolita, learned counsel appearing for the petitioner.
Yes, that's-
Mr.
Yes, that's
And Mr. S. Das for
standing council higher education, my lord.
standing council higher education, and Mr. Oh, S. Bhuya is also same. A prayer is made on behalf of the prayer is made on behalf of the respondents to file their counter. Although two times adjournment was taken for the said regions. As such, only 2 weeks further time is granted for the as a last opportunity for the respondent to file their affidavit. List this matter again on 2 weeks, right? 1, 2. On 10th of June. On which date the respondents would file their affidavit without fail.
That's all.
How, Mr. Bhuya? No affidavit again?
We are, my lord, pleadings are completed, my lord. The issue is as regards, my lord, selection and appointment for the science.
Pleadings are complete, you are ready?
Yes, Your Lordship,
Madam.
we are ready, but not today, Your Lordship, because NJ Khatanier is taking care of this matter. So due to some personal difficulties, he couldn't be here today, Your Lordship. So I'm taking a time on behalf of him, Your Lordship.
So, today is what? Tuesday.
Today is
Day after
Tuesday.
tomorrow?
My lord, Thursday can be.
No.
Thursday.
When
Can it be on next week, Your Lordship, because I didn't have any confirmation whether he'll be here on.
next week again there is a difficulty 27, 28. There can be, I don't know which day will be our
28.
holiday. 27 will be cancelled.
No, my lord, it has been fixed on 28th, my lord.
So that will be changed.
My lord.
So 26th, can you do on Monday, Tuesday?
Tuesday,
Fine.
yes, Lordship.
Okay. On the prayer made by Miss H. Terangpi, learned counsel for
Secondary education.
learned standing counsel for secondary education, list this matter on 26th of May.
My lord.
Wait 1 second, 26th of May, no? Hold on, hold on. 26th of May, 2026. Oh, Mr. A.R. Bhuya, learned senior counsel, assisted by Mr. Anjet Chaudhary, is present for the petitioner. It report did you?
Obliged.
Obliged.
Only in this case, matter relates to release of pension.
Talukdar, you are ready?
Well, matter can be disposed of, they have admitted, only direction may be issued, my lord. I am a stipended teacher, dishonorable put in earlier round of litigation, provided that pension should
It's
be.
already one. So we will start at 2.
Yes,
Okay.
yeah. As per their affidavit, that can be disposed of.
As per their affidavit. They have considered to your request. Oh, then it's very good. It will be a short order.
Yes.
Habo. It's okay. Yes.
So item 25, they ought to mention the matter in the morning, Your Lordship. May Lordship, with regard to item 24, 25 and 26, Lordship, they're connected matters. Lordship, we had taken concern in the morning itself, however, we failed to mention it. Lordship, I'm appearing for the BTC in this case, Your Lordship. We'll be filing our affidavit in the next 2 weeks, Your Lordship, so.
Acha. So, 25, 24, 25, 26.
Lordship.
Okay. On the prayer made by the learned counsel for the BTC, that they would file an affidavit. The prayer is allowed, has sought for some time. Prayer is allowed. List this matter when? List this matter after 3 weeks. List this matter on 17th of June. Will it be very late? 17th of June.
Lordship, there's an interim order operating also, so Lordship can post it on the second week.
You are for petitioner.
For the respondent, Lordship.
Interim order was by him.
Lordship.
So interim order is there.
Yes, Lordship.
Interim order passed earlier shall continue until the next returnable date.
Lordship, the interim was absolute.
Oh, then it's not required.
Sure, absolutely.
Not required. Interim order not required.
Are you good?
Yes. What is this case about?
My lord, petitioner husband was appointed in the year 2021
Hmm.
as stipended teacher, and
Yes?
husband's service was regularized, my lord, with effect from 2010-2012. And
No, he is a husband appointed when?
on 8/3/2001,
As?
as teacher, LP school teacher, my
Mm.
lord, on stipendary basis.
Mm.
And receive regular scale of pay from 2010-2012.
Mm.
And died on 16/6/2014
Mm.
while serving at
While serving at?
Tinthengia LP School under
Achha,
Bipura Block,
okay.
Lokhandwar district.
Hmm.
Thus, I had a batch of writ petition regarding stipend and approach this honorable court. And this honorable court held that
What is the difference with stipend and salary?
stipend, initially they will receive some stipend, 1,800, 2,000, etc.
Hmm.
After completion of the junior basic train at the relevant point of time, they were allowed to draw regular scale of pay. And there is no dispute, they have also admitted.
Mm.
And this honorable court held that all the stipendary teachers, they are entitled to covered under the old pension scheme 1969.
Mm.
But inadvertently, our case was tagged as OVB because in the common judgment, OV teacher and drop teachers were not
What
allowed.
teachers?
Drop teacher, drop
No,
math.
before that you said something?
My lord, in the common judgment on order which has been reported, our names were illegally, unfortunately tagged with the OVB teacher. Then we filed OVB,
No.
Operation Blackboard. teacher.
Oh, Operation Black
Yes.
OBB teachers. Okay.
Then we have approved this honorable court by way of an IA. Then the government has submitted, government council has submitted, yes, they should be included in the stipendary teacher except serial number 28 and 30 in the
Hmm.
in the writ petition. And accordingly, direction was issued page 31.
Hmm. Yes, 31. Hmm. Hmm.
While disposing the IA,
Hmm.
paragraph 4,
Hmm.
Mr. P.N. Sharma, Lanet Sundays Council submitted on instruction issued by the director that it was mentioned that all the petitioners in in our petition would come within the ambit of stipendiary teacher except the petitioner number 28 and 30. Under such circumstances, this court is of the opinion that the petitioner in except the petitioner shall be entitled to the benefits of granted to the stipendiary teacher. Then we have approached the honorable court before the authority, and the department has now filed an affidavit. Yes, they are entitled under the stipendiary teacher, and they have verified the list as per paragraph 6. They have stated an.
So what have you challenged in this petition?
Well, since the order has been passed, till that the benefit has not been extended.
Achha, even after this order, no authority has passed no order.
No order.
Allowing them stipendiary scale.
Yes.
So you have come before this court. Now in affidavit in this particular petition.
Yes, paragraph 6, they have all.
Page 37.
Wait, page.
From paragraph 4 onwards,
37.
they have admitted, my husband was appointed. Paragraph 4 onwards, the Sri Dharmendra, husband of the petition, was appointed as stipendiary teacher in so and so, and fixed pay on and died on so and so. Then paragraph 6.
He did not complete his training.
But I have complete, my lord. In the meantime, my husband died, so I will get the pensionary benefit of my late husband.
So you were not paid, your husband was not paid scale of pay, regular scale of pay.
Regular scale of pay.
Achha. Here it's written that completed his requisite training. Okay.
And in person of so and so, the husband of the petitioner was allowed to draw regular.
Achha. Okay.
It is clear mentioned that in the appointment letter so and so.
Okay.
Initially 1800, then after completion of 1 year service.
So okay, in view of their admissions.
Yes, paragraph 6. Sentence. In terms of the honorable, in compliance of the honorable High Court order 31 2023 passed in so and other link cases, and in persons of Govdan Letters, the DE has submitted the verified compliant list of stipendiary to the government on 16/10/2025, wherein the name of the husband, the petitioner figured at serial number 160.
So this was after you filed the writ.
Yes, ma'am.
So in view of this, it can be disposed
Yes,
of.
ma'am,
That-
in a
that-
time frame, my lord. And died in the year 2014. I am with very benefit. So I'll get something.
Yes, Mr. Talukdar?
Was reflected in the first order also, 31/10/2025, while issuing notice.
Which?
Was in the orders.
Achha.
First order.
Petition.
The order that you had shown was in the IA.
Yes,
And what about the main writ petition?
main petition has been disposed of, directing that the stipendiary teacher will cover under the whole pension scheme, but except stipendiary teacher like OBB teacher, Operation Blackboard teacher, their cases has been rejected. They have clubbed different group of teacher.
Punima
In the Punima Hore-
There is no issue of old and new pension rules, right?
No.
So he will be covered by old pension scheme.
The time frame, within time frame, they shall complete the process as per their paragraph 6.
Heard Mr. Sharma and Sharma, learned counsel for the petitioner, and Mr. B. Talukdar, learned standing counsel
Elementary education.
of Elementary Education Department. By this application filed under Article 226 of the Constitution of India, the petitioner has prayed prayed for a writ in the nature of mandamus, directing the respondent authorities to grant the family pension to the petitioner under Assam Services Pension Rules 1969, in terms of the order dated 28/6/2023, passed in IA number IA within bracket C number 1238 of 2023, by which it was directed that the husband of the petitioner was a stipendiary teacher. Where is that IA's order you had just shown? No, yes, yes.
It's 32.
কি বুলি কলো? The husband of the petitioner? Stipendiary teacher, and that all benefits should be given to him. The case of the petitioner is that, oh yes, the case of the petitioner is that her husband was appointed as a teacher in the year, appointed as a teacher by order dated 8/3/2001. And thereafter, her husband was paid, was regularized, right? Regularized in the service of teacher by order dated 2010/2012.
With effect from
Where is that? With effect from?
2010-2000.
No, order is dated what?
Well, order is a common order, but effect is there.
Where do I get it? Oh, he was regularized to his service. With effect from 2012.
Yes.
With effect from 2010/2012. It is stated by the petitioner that her husband died on 16/6/2014.
Paragraph 4, it has been stated by the department and with effect from 2010-2005 DE Assam order dated
5.
Paragraph 4 of the affidavit filed by the department. Last sentence, in persons of the government when dated so and so, the husband of the petitioner was allowed to draw regular scale of pay with effect from 2010-2012.
12, yes, 12.
DE Assam order dated
2010/2012 je kolo, by order dated 19/12/2015. The petitioner further states that that her husband died on 16/6/2014. Acha, why did you file that writ petition?
petition filed
Wait.
the year 2012.
While died on 16/6/2014 while serving in his school. While serving in his school, full stop.
At Tingthengya LP School, Bipuria Block.
Acha, you can give that name. No, appointed a Didier. Appointed as a teacher, no, assistant teacher.
At Pakadol LP School, Lakhimpur, and died while serving at Tingthengya LP School.
Oh, acha. These are two different. He got transferred in between. Right.
Maybe.
He died while serving, while serving at Tingthengya LP School under Bipuria block. Full stop. After the death of the petitioner's husband, the petitioner approached the authorities for release of service benefits as well as pension, as her husband, as well as pension. But the said prayer was never acceded to by the authorities concerned. And aggrieved thereby, the petitioner approached this honorable court by filing writ petition being WPC number 4355.
4353.
Oh, 4355. I wrote written wrongly. Writ petition being
4353.
4353.
Yes, madam.
Where is that order?
Page 31. Second sentence.
4353 of 2022 for pensionary benefits under the Assam Service Pension Rules 1969. And the said writ petition was taken along with other similarly situated, with other similar writ petitions. And this honorable court, by a common judgment and order dated 31/3/2023, held that stipendiary teachers are entitled for GPF and other pensionary benefits under the 1969 rules. Full stop. However, the petitioner states that this court, while disposing the writ petition, had categorized some teachers under the blackboard teachers category.
Our case was club as taken as Operation Blackboard teacher, which are not entertained. Then we filed
This was a
page 32.
writ petition. Here, the petitioners were characterized to be under the blackboard
Yes.
teachers
Then
category. Then you filed an
IA.
Blackboard teachers category. The petitioners, being again aggrieved, filed an interlocutory application being IA number 1238 of 2023 for correction of the said inadvertent error that had crept up in the judgment and order dated 31/3/2023. And then this order was passed, right?
Yes.
28/6. And after consideration of the said case, this court, by order dated 28/6/2023, had held that the petitioners, except petitioner number 28 and 30 in the said writ petition, are stipendiary teachers and they are entitled to all the to all the benefits.
And my name was at serial number 12, page 17.
Serial number 12 of that writ petition. And the petitioner's name, now here only one petitioner. And the name of the petitioner, a name of the husband of the petitioner, or what?
The petitioner.
That time, before that only husband died, right?
Husband died, therefore
A name of the petitioner was at serial number
12
of the said writ petition. However, what happened? After that, it was not considered. You had
not considered.
filed representation.
Yes, sir. One of my colleagues had filed page 34 for compliance.
Thereafter, one of the petitioner of that writ petition being similarly situated. Who was similarly situated as that of the present petitioner, submitted a representation before the respondent authorities, along with the copy of the order dated 28/6/2023.
That is respondent petitioner number 3.
Okay, he was there. But the said representation was not acted upon by the respondent authorities. As such, aggrieved, the petitioner has filed this instant writ petition with the aforesaid prayer. During the writ proceedings, who is respondent number 2? The director. During the writ proceedings, the director of the District Elementary Education Office.
Director of Elementary Education.
Oh, the Director of Elementary Education, Assam, filed an affidavit in opposition stating inter alia that the petitioner, inter alia, verification was done. কি কলো? Affidavit in opposition stating inter alia that pursuant to that order dated 13/3 is not the order in the IA. What was the order in the IA? Dated?
28/6/2023.
Pursuant to the High Court's order, the concerned authorities have verified the list of stipendiary teachers wherein the name of the husband of the petitioner figured at serial number 162. Full stop. As such, it is seen that the petitioner was considered as a stipendiary teacher and not under any other category. However, the husband of the petitioner, husband of the petitioner, was considered as a stipendiary teacher. However, the husband of the petitioner expired in 16/6/2014. That is, he died in harness while serving in the school. As such, the petitioner, who is the wife of the said employee, is entitled for all the benefits under the pension rules of 1969. Contentions and all I need not to write. I'll give the final order. Okay.
Yes.
Not required. It's a small thing. As such, this court finds it fit to direct the Director of Elementary Education
Respondent authority.
or other
Respondent
respondent authorities.
Because finance.
Direct the respondent authorities to grant the family pension to the petitioner But whether he'll be under the old pension scheme,
Yes, ma'am, all pension scheme that has been admitted.
because he was appointed in 2001, but he was regularized in 2012.
Therefore, Honorable Court held that if the appointment was made prior to 2005, but they were sent later on, all the stipendary teachers are entitled to old pension scheme.
Where is that?
In the original judgment.
31.3.
Yes, my lord.
So 31.3 is judgment you have.
Yes, ma'am, main judgment is.
You have not annexed here, right?
This is a very big one, ma'am.
Acha, give me that.
Paragraph 22, stipendary teacher. An operative part is last.
Further, it is seen that this court, by order dated 31/3/2023, passed in WPC number 6403 of 2021, had held 22.
Yes, ma'am. Paragraph 22. Stipendary teacher.
And amongst these writ petition, your writ petition is also there.
Yes, my lord.
Yours was 5843, no, yours.
4353.
Huh?
My repetition was 4353. But actually it was OBB, therefore it was IF was filed for application. The Honorable Court held that the order passed in that judgment will also cover in my case. Paragraph 3 of the main, page 32 of the
Page 34 of?
Page 32.
Of this petition.
Yes, 32. Paragraph now, it appears from the that all the petitioner in except the would come within the ambit of stipendary petition. This court might order issued notice thereby directing the standing counsel for elementary division to verify whether the petitioner come within the ambit of the stipendary petition. Then paragraph 4, they have admitted.
Yes.
Then paragraph 5.
It's okay. So they are considered to be stipendary teachers, right? Okay. So what is this? It was held that although the training period was little later and they were confirmed later, but it was not in their hands. So since they were appointed earlier, before 2005, so but then it's not that clear. The old pension, the ROP rules there it is talking of, but not the old pension scheme.
Yes.
See where it is, mark that.
The operative for last page.
It's a long judgment. You see and let me know. You must have gone through.
Is also reported.
Now reported. Reported in, this is Purnima Hore.
Yes, ma'am, Purnima.
This is reported in 23 GSCC online. Just show me about the pension rules. Hey, date of death is not 16/6, 11/6. He expired on 11/6 দিবা হা দুটামান টেকাত দিছো নেকি 11/6/2014 মই 16/6 কৈছিলো নি 11/6 কৰি দে
Paragraph 34 is 73.
paragraph 37
34 in the main petition. And page 138 and
you mark it a little
138 and 73. Paragraph 34 and 118.
$34 and 118
Yes. Eight, one.
34 I'll see first okay one one eight
118, paragraph 118,
1
all the stipended teachers.
and they are not covered under the NDCPS is what new pension scheme
New defined pension scheme.
no but I want the answer to the query that although they were confirmed or regularized later but their appointments being before 2005 they'll be regulated by old pension scheme
Yes, that statement,
that where is that
that observation is there, man.
the writ petitioners who come within the stipendary teachers I understand okay
All the stipendary teacher, they were appointed prior to 2005
Achha.
in that group.
After regularization there will be regular pay scale
Yes, there.
so stipendary teachers before 2005 will be covered had held that the stipendary teachers appointed before 2005 would be entitled under the old pension scheme of 1969. As such, this court, এইটোতো ক'লোৱে ন তাৰ পিছৰ পেৰাগ্ৰাফটো আহিলে এইটো yes grant the family pension to the petitioner under the Assam Service Pension Rules 1969 with other financial benefits. From the date of the death of the husband of the petitioner. From the date of the death of the husband of the petitioner, that is 11/6/2014. The petition is disposed of.
Time frame maybe 2 months, 3 months.
Oh, yes. The said exercise to be completed within a period of 1 month from the date of the receipt of this order. The petitioner is also directed to place the certified copy of this order before the respondent authorities at the earliest.
1 month, 2 months, 1 month. Cannot.
1 month will be less.
Yes, maybe 1.
2 months. Petition is disposed of. Acha, you take your order. Yes.
My lord, petitioner seeking family pension. My lord, instruction was sought for earlier occasion.
Not
My lord,
received.
I have received, my lord. Here only thing is that, my lord, pension, family pension will be granted by the, my lord, director of pension, my lord. Initially, my lord, petitioner has received his
There
pension,
are so many communications in between them, right?
my lord. The thing is that they have to approach the director of pension, my lord. Education department.
Director is, my lord, here the director of pension is party here, my lord.
What is your instructions?
Here, my lord, husband of the petitioner already received the family pension.
He died.
He died.
Now the petitioner is seeking pension.
Petitioner is seeking family pension.
So what is the problem in that?
Only thing is that they have to approach the director of pension, my lord, education department.
Husband died after retirement?
Yes, my lord.
After retirement?
He was receiving the pension.
Pension.
And on 27/6/2023, he died.
So after that, wife will definitely receive if unmarried daughters are there.
Yes.
Then
Director of pension is,
Now proposal has to, my lord, sent by the concerned department to the pension department. Now I have submitted representation that has to be forwarded to the, my lord, pension.
your
department.
representation is required or your simple.
Already I have submitted representation, my lord, that is page 9. That has to be sent by the department to the pension. Directly.
So only an intimation would do that her husband died and now the family pension will be half or whatever to the wife.
my lord.
So what is the difficulty in it?
Well, here some documents are required, probably they have not submitted, my lord.
That he is the wife, she is the wife,
She is the wife.
she is alive.
She
Well,
has to
those.
She has to submit, my lord.
So those documents we have not submitted.
Already, my lord, in the, my lord, director, district elementary education officer, a hearing was conducted. My lord, the petitioner appeared there. She was called, my lord. And she submitted all the relevant documents there. Now,
Then
my lord, I think they are not with the proper instructions.
I have the instruction, my lord. They are in the instruction, it is stated that, my lord, she has stated before the inquiry committee that some of the document along with her.
Only that
son.
PPO, my lord, only that PPO, that, my lord,
Original
I
PPO.
have lost, my lord, that I have already stated before the authority, that PPO with the pension department, that may be, my lord, verified. The,
no, you take out then if you have lost that PPO, then you have to apply for the.
PPO number I have, but the original order, my lord, that is not with me. After the death of my husband, my lord, I was, my lord, driven out from home. And after the death of my husband, and
You were driven out.
Children, my lord, I was driven from home, my lord. That's why.
First wife is there alive.
No. She died. After
The children of the first wife had driven her away.
my lord.
Whatever it is, you have to submit the documents. Now, pension payment order, if you have lost it, then you have to get it, get a copy from the authorities, then submit it. It is not their duty, right, to get your pension payment order. Or it is, I don't know.
No, PPO has been provided by the Department of Pension, Director of Pension. my lord.
My lord, kindly see page 9. My lord. Now what happened, my lord, I'll clarify. This is the application, my lord, she has submitted before the district elementary education officer. She approached even the director of pension. Director of pension, my lord, asked her to file a representation before the DEO
Mm.
Stating that DEO will send the proposal to the, after verifying all the documents and all, proposal to the director of pension, and director of pension will finalize the family pension.
So
Now,
DEO
my lord,
too.
I am regularly, my lord, approaching the DEO, and I have submitted all relevant.
Without PPO, how can it be possible?
But you have not submitted your PPO.
No, I can't get, my lord. Only the PPO number which I have, my lord, I have mentioned.
There is a way of working of all the authorities.
My lord,
So
now,
how will they proceed? How will they give the instruction to the pension officer?
now, my lord, the district elementary education officer, that officer may seek seek
can
a
it be-
copy from the director of
Why
pension.
will they seek a copy? You seek a copy.
Then a
It
director.
is for you. Money will be given to you. Have you seen somebody else working for somebody else? You seek a copy and then you submit, then things will be done.
That my lord, I was asked to submit application before the DO, saying that DO will.
Again, you are repeating the same things.
Here, my lord, in his representation, he has stated that I have lost the
Mm.
original PPO.
Original
Then,
PPO.
then petitioner should have filed an FIR, my lord. Thereafter, he has to approach the director of pension for issuing a fresh one, my lord.
Those things has to be done.
My lord.
By some police information.
My lord.
Or by affidavit or by something. You take out the copy of the pension payment order from the director of pension. And then you submit it before the DEO. Only you're writing that I have lost it. And the DEO will procure. Why will DEO? They have no other business or what?
My lord, may I suggest one thing, my lord? Kindly, my lord, matter may be adjourned for the day. My lord, I'll take the fresh instruction. My lord, the petitioner, my lord.
What fresh instruction? You have written in this representation that you have lost.
My lord, what is the development, my lord? I'll have to take instruction, my lord.
Or I can order that you take out a copy of the PPO from Director of Pension and you submit it. Right?
But, my lord, PPO has to receive from the director of pension, my lord.
No, he will procure it from Directorate of Pension
My lord.
and then he will give it to the DEO who will further instruct.
My lord.
Right? Heard, Mr.
M. Ali.
M. Ali, Learned Counsel for the petitioner, and Mr. P.K.
Bora, my lord.
P.K.
Bora.
Bora, Learned Standing Counsel for
Elementary education.
Elementary Education, and Miss
E.D. Burman, additional senior government advocate.
additional for respondent number 3. By this application filed under Article 226 of the Constitution of India, the petitioner has prayed
In this case, Lordship, the next of kin certificate is also not available, whether she is the second wife of.
So she will submit all the necessary documents, including the PPO,
Yes.
which she will acquire from the Directorate of Pension. And other required documents before it, and the DEO will verify it, and send the final instruction to the Directorate of Pension, who will release the pension to her, right? Now, by which the petitioner has prayed for release of pension, for release of family pension to her, for release of family pension and other pensionary benefits to her, which is due to her deceased husband. Yes, to her after the death of her husband. When did he die?
27/06/2023.
27, who died on 27/6/2023. Full stop. The petitioner has also prayed that the representation she submitted before the district elementary education officer should also be disposed of without any further delay. The case of the petitioner is that her husband was working as a teacher, right? Was serving as a head teacher in Haltorpar LP school. LP school, Katigora Educational Block, and that after retirement, he was drawing his pension and subsequently her husband died on what date you said?
Alert 20.
It died on so and so. Died on so and so.
PPO order, number of PPO order may be mentioned.
That may not be correct.
Number of PPO order, why it's required? You will get a order from the director of pension by following the due procedure. Name number will be there, name will be there.
It is there. Your number is.
And after the death of her husband, the petitioner was not getting her pension and other pensionary benefits. The petitioner further states that she made an application, or she made a representation before the district elementary education officer on 15/9/2025, praying that she may be granted pension from the date of her husband's death. Full stop, para. The learned counsel for the petitioner, however, submits that the petitioner had lost the original pension payment order, which was also written in the representation. Full stop. The counsel further states that the petitioner has the number of the PPO with her, but she lost her original payment or pension payment order. And that the said fact was written in the representation, but the authorities concerned have not responded to the said representation. Full stop. He further submits that the petitioner is entitled for her pension and other pensionary benefits. On the other hand, Mr. Yes, Bora, learned standing counsel for elementary education, submits that he has his instructions from the office of the DEEU, right? District Elementary Education. From the DEEU.
Director Elementary.
He has the instructions from the Director of Elementary Education, wherein it was stated that the petitioner had not submitted all the required documents for verification and for an effective instruction to the Directorate of Pension for releasing the pension to the petitioner. It is noticed that the pension payment order and other relevant documents were not placed by the petitioner before the DEEO. And as such, it could not be processed. Para. The petitioner had also, nalage para, it is noticed of a para dia. The petitioner had also stated that she has lost the original PPO and that she has only the number of the same. And as such, she could not place the said order before the DEEO. It is as such directed that the petitioner would apply the said pension payment order. No, apply for a copy of the pension payment order before the Director of Pension. Huh? Duplicate copy. For a copy that will include duplicate pension. And it is further directed that if some exercise is required to be gone into before applying for the same, such as intimation to the police regarding the loss of the said certificate, loss of the said order, or any other required procedure, the petitioner has to go through and do the same. And once a copy of the pension payment order is supplied by the Director of Pension to the petitioner would submit the same before the Director of Elementary Education, before the DEEO, District Elementary Education Officer, along with other documents. And on receipt of the said documents, the DEEO is further directed to do the needful for releasing the pension and other benefits to the petitioner, such as giving effective instruction to the Director of Pension. The said exercise. No, it is subject to their approval. The petition is as such disposed of. Nothing further. You will do it. You will get a copy, deposit to them. Then they will process it.
After my application,
Acha, you can do one thing. The exercise by the DEO, after getting the necessary documents from the petitioner, should be done from the petitioner, and further the exercise by the Director of Pension for release of pension to the petitioner should be done within a period of 2 months from the verification, from the successful verification of the documents by the DEEO. Okay.
all right.
Petition is disposed of. Any small changes here and there, I'll do.
Make please, Your Lordship. So this is a matter where the first statute of the university were not yet approved. This is a matter where the first statute of a university is not yet approved. The law says that after application,
within 2 months, either it has to be approved. Now, this university was set up, UGC recognition was granted on 24.
So who appears for higher education? Higher education?
Higher education.
Okay, but last time you were supposed to
they were
bring
supposed to
instructions as regard decision taken by cabinet.
Yes, my lord.
So,
In the last cabinet, just before the model code of conduct,
Mm.
this matter was not decided,
not decided.
not decided.
They will take it up now.
I have no instructions, my lord, they will know.
What has happened, madam, on last occasion?
Not have it sitting and therefore he praised the matter we listed after so and so. So now it will be taken up.
Now, madam, the new government is formed, but the ministries are not formed yet, madam.
It will take some time.
My lord, the act does not say, the Assam Private Universities Act does not say there's a cabinet decisions mandatory.
Oh.
That is the sole question. If I may put the act, my lord, if your lordship just have peruses the act.
Mm.
Sir, এখন কি বলতে?
That is the standard practice actually.
As does many has please instruction which regularly the issue of approval of the court. Now university the same has been pleased before the cabinet meeting of the college. Acha, you had stated that ground earlier also,
My lord.
and you wanted some time to go through the rules properly. So cabinet approval is not required.
My lord, what has happened, I'll just put it in. My lord, we had applied our first statute in 22/12/2000.
So you means the Girijananda
Girijanand, the university.
University.
Now, we have given the statute. Now, the respondent authorities. what they-
Statute means your law.
By law, first statute, the governing statutes of our university. The respondent authorities asked for some modifications, some deletions, some additions. They sent it. back.
Respondent authorities are who? Higher
Higher
education.
education. They sent it back to us, asking for some modification, rightly, my lord. After incorporating that modifications, we have again applied it before the authorities. That was in 15/6/2023. Law says within 4 months, 2 months, they have to allow the statute.
But correction was sought for.
Yeah, correction. After giving of the correction, it was given in 15/6/2023.
But they are sitting over.
They are sitting over it.
Within 6 months, they have to give.
Within 2 months, my lord.
Oh, within 2 months.
And my lord, what I want to say that if the cabinet decision is mandatory, then when they returned our statute on the first instance, asking for some incorporation, there was no such cabinet decision that you have to incorporate this or you have to delete this much. It was taken by the respondent authorities and the higher education department.
So cabinet is actually not required when you had asked for modification, not required. So now.
I have spoken to the authority, my lord. Although there is no specific mention in the act, my lord, of Private University Act, but they are saying that this is the standard practice they follow, my lord. While in every
Something
private
if it's
university, my lord,
done
like-
wrongly, why should we follow? Whatever is provided under Assam Private Universities Act will be followed.
There, I think no specific word is there for to place it before the cabinet. That's true, my lord. But the thing is that whether it is mandatory not or it is a general practice, my lord, for that, my lord, I have to take further instruction or written instruction, my lord. Because my lord, there is submitting, my lord, without my written instruction, my lord. What I have spoken to the authority, my lord. They are saying that
There cannot be any notification and all those asking for because.
Your lordship takes up this act, the flag mark page 1801. The act that is flag mark page 801. My lord will take subclause 3. This is 30 subclause 3. The state government shall consider the first statutes submitted by the university and shall give its approval thereon within 2 months from the date of its receipt and with such modifications, if any, as may be deemed necessary. My modified statutes, as per their instructions, was submitted in June 2023. Is it their ground that cabinet has not set after that till today?
And it's only for the state government working in
Exactly.
higher education department.
The commissioner and secretary.
So government in higher education department will do it.
No,
Cabinet decision as such is not, I don't know, I have not seen the entire act. and within 2 months from the date of its receipt and with such recommendation, if any. So 2 months will also cover any recommendation, modification and all.
And then,
Like if-
leave apart, my lord, that boat has sailed, I understand. But even then, 15/6/2023, we have submitted. It is going to be 3 years almost. I say the last 3 months may be wiped out. But is it that case? 2 years, 9 months, cabinet has not set. Where there's no strict mention of that, it has to be before the cabinet. It's a state government. The word.
Acha, you bring those instruction as to whether any cabinet decision is required. Otherwise, rule doesn't provide so, as far as what I'm told. And then if there are any norms, practice, some notification, nothing, something, bring those.
On last
But
occasion,
within 1 week, you have
on
to bring,
last-
see, 2 months, the statute should have been approved of.
on last cabinet, my lord, it was placed, however, that matter was deferred, my lord, due to some reason.
Because it is not required, perhaps. That is why it is deferred. No.
Other universities also, my lord, like Royal Global University and all are, my lord, approved by way of placing the statute in the cabinet. My lord.
And if it is deferred, there has to be some reason for deferment. Suppose they were not happy with our present statutes. They could have said in 2023, when we have submitted the second revised statute.
My lord, give me some time, my lord, I'll bring instruction or.
Okay. Heard Mr. D.K. Bhattacharya, learned counsel for the petitioner, and Mr.
S. Das, my lord.
S. Das, learned standing counsel for Higher Education Department, representing respondent number 2, 3, and 4.
My lord.
And you are there for respondent number 1. Yes. And so, and also so and so for respondent number 1. No, okay. The case of the petitioner is that the petitioner has submitted the first statute before the Director of Higher Education for its approval. And that it was sent back to the petitioner for incorporating certain modifications and alterations. And in pursuance to the same, the petitioner has modified the way it was asked for and again submitted its first statute before the Director of Higher Education on 15/6/2023 for its approval. Full stop. However, the petitioner submits that till date, the approval has not been granted. The Learned Council for the Higher Education submits, oh no, Taragotidia. Mr. Bhattacharya further submits that the approval is to be given by the state government in the Higher Education Department. As per Sub-Rule 3, what is this? Section
30 sub-rule.
Section 30, subsection 3 of the
Assam Private Universities Act.
of Assam Private Universities Act 2007. The Learned Council for the Higher Education Department, however, submits that the issue of approval of the first statute submitted by the petitioner was placed before the cabinet on some date, you said, cabinet on 10/3/2026, and the same was deferred to be considered later. On the submission that cabinet approval is not required in such cases, the learned counsel submits that he would take further instructions in view of the fact that in case of other universities or colleges, cabinet approval is granted. In view of other universities or colleges established under the Assam Private Universities Act 2007, cabinet decision, cabinet approval is granted. As such, it is directed that the learned counsel will place the necessary instructions on the next date, together with the reason for deferring the said issue by the cabinet on the last date of placing the same. Last date, on the last date when the said issue was placed before it. Anything more? List this matter again on 8th of June.
My lord, after that week, my lord,
15th of June.
15th of
15th of June 2026. You bring your clarification on this, whether required.
whether it is mandatory
Oh.
and, my lord, the.
And why was
reason
it
for the
postponed?
deferment.
Whether it is required to be placed, mandatory, same. And why was it postponed on the last occasion? If they say, no, it's not required, so we will not go into it, that can also be a reason.
Can be reason.
Huh?
Obliged.
Orders. Last time also none appeared. None appeared. Number of times.
Well, here petitioners were accommodated as tutor, my lord. They have received, now receiving their salary, my lord. That is why probably they are not appearing before this honorable court. Here they have claiming for area salary, my lord. They are now accommodated as tutor.
We'll give a last opportunity if they do not appear on the next day. None appears for the parties on call. It is also noticed that on 2 earlier occasions, the counsels for the petitioner had not appeared. As such, on the next date, if the counsel does not appear, adverse orders would be passed. List this matter again on 17th of June.
This is a contempt.
Contempt case?
Lordship.
9 years is pending, my lord, since 9 years, my lord, to pay the salary, my lord. They are this or that, not they are taking adjournment, my lord.
So, when was the last?
They have created, my lord, proceeding be drawn up against them. Even they have not filed counter affidavit.
Why?
Lordship, I'm appearing on behalf of Mr. B. Kaushik. Last opportunity may be given, Lordship. Matter will be listed after 2 weeks, Lordship. He has some instruction. He'll file an affidavit, Lordship.
Okay, last opportunity.
My lord, you may see that their attitude, my lord. First, I took your lordship to the order dated, my lord, 11/6/2025.
So many orders have been passed in this case.
9 years, my lord. Petitioner
When
has
this
already
is
retired,
2017.
my lord.
I've not seen the year also.
My lord, only to pay the salary. Direct order is there, pay the salary. In spite of they have not paid. They have filed.
Next week, any.
They are not taken sanction post or what? What happened? They are temporary.
No.
You don't know, right?
No,
I don't know.
Everything
Next
is
week,
okay.
next week, any day, Lordship.
Okay, next week any day. Who is your senior?
Mr. B. Kaushik, Lordship.
Oh, B. Kaushik.
My lord,
Okay.
maybe at the last, may I pray that, my lord, one thing, my lord. They may be asked to appear, my lord. Then they will pay that.
No, Lordship, last
Last opportunity, I'll record these
Last
submissions.
3 orders, my lord. They are getting Again, what is this? 9 years?
1 week I'll give, and if they do not appear, and again this submission is made, we will take up this contempt
Well,
case
maybe-
without any
Ah,
pleadings, without anything.
Everything may be
Hmm.
clear.
Heard, Mr.
Again,
A.K.
Maheshwari.
Maheshwari, learned counsel for the petitioner, and Miss
K. Bharali on behalf of Mr. B. Kaushik.
K. Bharali on behalf of Mr. B. Kaushik, learned counsel appearing for the respondents, all contemners, all respondents. How many are there?
Oh my, 3 and 4.
Who are 1 and 2 replaced?
1 and 2 are already retired, madam.
Replaced, okay. For the respond number 3 and 4. Miss Kolita you said?
Bharali.
Bharali. Miss Bharali submits.
My lord, as per the record, my lord, B. Kaushik is not there, madam.
But on the
But
last
he-
order it is there. On a request
No, he
made
has
on.
mentioned, my lord, but as per the Wakalatnama, he is not there in the court list, madam.
But department has instructed him to appear.
He is for the contempt. Of course, in the causal is no
Contempt
saying he
is,
must
madam,
have filed
He
Wakalatnama.
appeared, my lord,
On behalf of Mr. S.M. Sistilosh. If he,
SM Chistry is a government advocate.
no, he is a standing counsel of elementary education.
It doesn't matter. It's a contempt case. It's personal.
he had filed
Hey,
Wakalatnama.
don't know this. His name is there, SMT Sisti Lordship.
Call Mr. SM Chistry. I'll call. I'll take
He
up
is
after
not
some.
their lordship. Actually, he is.
Achha, see who has filed a Wakalatnama on behalf of the contemners?
My lord, as per the court list, my lord, SM Chistry name is there.
Which item number?
Item number 28.
8.
28.
Oh, respond number 3 and 4.
My lord.
And even D. Saika's name is there. This is a contempt petition.
My lord, they have treating that like a department case, my lord, so that they need not need to pay the payment.
Okay. On behalf of SMT Chistry likha, huh? On behalf of SMT Chistry. Miss Bharali submits that affidavit in opposition has not been filed in the instant case on behalf of the respondents, and that she prays for a final opportunity to file the same. Prayer is allowed. However, with the direction that if the affidavits are not filed by the next date fixed, this court would proceed with the contempt case, which was filed in the year 2017 and pending since then.
Next date is, my lord,
List this matter
Second June, my lord.
on 1st of June.
2nd June.
2nd June is a Tuesday.
Up to your
1st of June. Huh? 2026, by which date? Respond number 3 and 4 would file the affidavit positively.
Much obliged, Lordship.
Hearing na palugi ase. As side of the written day. Yeah. Item 29, what has to be done here?
Like this matter has been wrongly listed. This should have been listed in admission column. So my lord, if a matter is simple, if your honor insists, if a lordship insists, then lordship will take up the matter. For the
Wait,
court.
wait.
Lordship, here our instruction is required and moreover, Lordship, perhaps the record will be necessary here in this case. Because the claim of the petitioner is such that, Lordship,
Okay, you'll file your affidavit.
Lordship, we will file our affidavit.
Okay, then I'll direct it to be listed for admission. Let the affidavit be filed.
Lordship.
Affidavit or only instructions will do.
No, Lordship, here affidavit is necessary.
You had withdrawn your additional affidavit. There are something? Amendment of the writ petition?
Yes, my lord. Initially, I filed an amendment challenging the appointment order of respondent number 7, my lord. Thereafter, my
DK
client-
Bakshi, Learned Counsel, prays for withdrawal of the additional affidavit filed on so-and-so, further prays to file an appropriate application for amendment of the writ petition. Thereafter, you have not done anything.
No, my lord, but I will remain only confined to their affidavit, my lord, affidavit of respondent 7.
Then why such prayers are made?
Respondents number 7 is working in 2 schools, my lord. Same person, how can he work? In my
It
place,
also appears that petitioner had not taken steps in terms of file an appropriate application seeking amendment. Again, after 2 weeks for justice.
Because I had the instruction from my client that I will not disturb his appointment. Only thing is that he may be allowed to work in other.
So you will not file any amendment?
No, ma'am, that I have withdrawn.
Okay, heard Mr.
The second one?
Heard Mr.
Second one is
D.K. Bakshi, learned counsel for the petitioner, and Mr. Sharma.
And for respondent for 7.
Acha, wait, Mr. What Sharma, you right?
P N Sharma.
P. N. Sharma, learned counsel for learned,
Education Department. Elementary education.
learned standing counsel for elementary education, and Mr. and Sharma for respondent number 7.
if required, my lord, I will file reply to their affidavit.
I have filed affidavit.
First, let them file the affidavit.
In the box.
There are already some affidavits here.
Yes, they have filed, I have filed reply.
It is for the respondent, private respondent.
577.
And may I take a lawsuit to one, two lawsuit? Initially, there was an IA filed, 2921, that was withdrawn. And subsequently, I think there is another IA, there was a direct, that is also withdrawn.
No, what has happened, let me tell you.
He withdrew the IA for.
Initial IA was withdrawn. The second IA was also filed in the month of November.
Initial idol was disposed with the order that the proper way the amendment should be filed as per the High Court rules in the.
Amendment of the petition.
Yes.
Ah.
So that was disposed of. Secondly, I have filed the second petition for amendment that I have withdrawn. It was disposed, earlier disposed, then withdrawn.
So none of the IAs are live.
Right.
So wait, one petition, one affidavit was for respond number 7.
Yes.
This is reply to respond number 7. Additional affidavit, so you have withdrawn? No. Additional affidavit you have withdrawn according to one order? Withdrawal the additional affidavit filed on so and so? Whatever it is, DK Bakshi for the so and so and it likhila. Mr. Bakshi submits that although he had stated earlier that he would file an amended writ petition, but when the matter is called up today, he submits that he will not be filing the same and he would confine his argument to the present writ petition. To the confine his argument to the pleadings made in the instant writ petition.
As well as the affidavits.
As well as the?
Affidavits of respondents.
It's okay, that will cover. I have a writ petition. Mr. U. Sharma, PN Sharma, learned counsel, learned standing counsel for elementary education, prays that he may be allowed some time to file his affidavit. The said, oh, you have to already file affidavit. Prayer is allowed. List this matter on.
After 3 weeks, lawsuit, any day.
On 12th of June,
Lawsuit.
2026.
Problem.
This
order is not we have
Mr. U. Sharma, you are supposed to file affidavit by 2 weeks.
we have filed already review, my lord, yeah.
Yes, one at a time.
This order is pending for the last more than 1 year. There is a clear mandamus lordship to reinstate being in service. Lordship may kindly see page 21.
Page 20.
Page 21.
The order
Lordship, the
under
relevant
which
portion,
contempt.
Relevant portion.
20.
Paragraph 25 and 26.
Page 21.
Page 21.
Order is set aside. Petitioner shall now be permitted to hold the charge of post of principal
Lordship. Incest.
of so and so till the same is so filled up on regular basis.
Lordship.
It is further provided in event there are existing with demonstrate commission of misconduct when hearing in the matter. It will be open. There are so many riders here. Whatever it is, you are supposed to
That is,
permit the petitioner to hold the post of principal till Norman selection is conducted,
Yes,
regular selection.
yes,
But in case the principal is found with some misconduct,
yes.
with regard to
then
new facts. Already
Huh.
there are,
any material comes to the knowledge.
oh, that was also done also, they did not find anything.
Disciplinary proceeding was initiated,
But not concluded, Lordship.
but not concluded.
Not concluded.
But again, there is a rider.
but
It would be
no
open to
disciplinary action-
examine
no
whether they would permit.
Disciplinary action has been initiated, Lordship. It was earlier, Lordship, the inquiry was done, and it has been, Lordship, in earlier paragraph, Lordship.
No, earlier I don't want. After this order.
No, this Lordship, the page 19, it is reflected in the order itself. This, there is no new complaint, no new fact. All the other have been already inquired, Lordship.
No, earlier things you leave aside. After this order, whether any disciplinary proceeding was initiated?
No.
No.
Their only complaint is that I have not completed 15 years of service as a PGT, postgraduate teacher in my school.
That is not a valid ground.
That is not.
You have to, if you start if you see any misconduct after this order, in how there are already materials, it is further provided in the event, there are already materials existing with the respondent authorities which demonstrate commission of some misconduct. Then in that case, and such materials comes to the knowledge subsequently, and that knowledge has come subsequently, then in that case you may not appoint him.
In this matter, we have filed one review petition challenging for review the order. And my lord, to be a principal, 15 years is required. 15 years experience is required as PGT is here. He has,
That was not error apparent. Why will the review be entertained? That was known to you. That is a law.
yes, my lord, but here, my lord.
So what
here
happened to
it is-
review?
It is stated that after serving, after having served for around 8 years in the school, a vacancy having arisen in the post of principal of the said school, the petitioner was allowed to jurisdictional inspector of the school to hold the academic search of the Kisnai Higher Secondary School, Gwalpara, filed order dated so and so. So, my lord, here it is stated in the judgment itself.
Now, what happened to the review?
Review, my lord, still it is not listed, my lord. So, my lord, some time may be granted so that it can be listed and the price.
Review is not listed.
Also, on the last two occasions, they made the same submission that we are contemplating to
This
file
is
a
the
review,
review.
then we have filed a review. On the last occasion also, they have made the same submission.
That's
that we have
not
filed
a-
a review.
So, my lord, some time may be
And
granted
also,
so
this
that
ground,
in the
that
meantime.
was not the
review-
issue in my writ petition. That I have not completed 15 years of service, but because they have appointed me as in-charge principal.
Admitted fact that you have worked for a lesser period, right?
Yes, yes.
Doesn't matter. You have not done that. That cannot be an error apparent. Review will ultimately be dropped. So first, you list your review application, get
Yes.
an order there, then.
Yes.
But when the review application is pending,
It was filed on, my lord.
like in cases of appeal being filed,
2020.
no appeal filed against that order, right?
No, yes.
Only review.
A review, yes, madam.
Review was listed last when?
Review was not listed yet, madam.
Not listed yet.
Yes.
When did you file the review?
24/4/2026. Some minor defect was there, madam.
Oh, now, just now you have.
A clerical mistake was there.
This order was of 23,
Of 22/1/2025, more than 1 year of.
25,
25.
22/1/25, and you filed your review after 1 year.
And my lord, Honorable Justice, you can our bench is also not sitting here, my lord. So, my lord, sometime may be guaranteed so that.
Some affidavit is filed by somebody. Who? Oh, affidavit is filed by the contender. Respond number?
It is
You.
Yes.
The director, this honorable court asked them what they are doing
Yes.
for the last 1 year. That is their explanation.
In this affidavit, have you mentioned about the review part?
A review part, yes, my lord. It is mentioned. What we have done till that it is mentioned here, and in the paragraph number 5.
I can see.
Yes.
Some modification, alteration.
Yes.
So why has it come up for orders today?
That's because it is a contempt matter.
Acha, affidavit is filed. Show me that application, review application.
Oh, yes.
The defect is cured
Yes.
and it is not listed till date.
Not, yes. Some minor clerical defect was there, madam. He has not mentioned the date, madam.
Okay, we will
In
take
our
up after
there
some
was-
time. You get the review disposed of.
Yes.
Right.
Lawsuit may give a fixed date also next week. Because
Heard Mr. S.K. Das, S.K. Das, right? Learned counsel for the petitioner, and Mr. U. Sharma, learned counsel for the respondent.
Yes.
It is noticed that the respondent has filed the affidavit in opposition on 26/3/2026. Wherein it is stated that a provision of law, wherein it was stated that steps would be taken for modification, alteration, and or recalling of the judgment and order dated 22/1/2005, the non-performance of which, non-compliance of which the present contempt application is filed. The learned counsel for the respondent has also stated that the Director of Secondary Education Assam has filed a review application with regard to the said judgment, and as such has prayed for some time so that the review application is disposed of, and after that, the instant contempt application be taken up. In view of the said prayer, list this matter again on 19th of June, 2026. Let's see what happened till 19th.
can it be also preponed also?
Hmm?
Can it be preponed also because usually because they have filed long back on in the month of April. If it is listed, it will be listed immediately not.
12th of June. Review খন দি দিব। Yeah, Mr. Sarkar.
Your Lordship, instruction received, Your Lordship. I would
Hmm?
like to place it. Instruction received, Your Lordship. I would like to place it. Your Lordship highlighted point 3 onwards. Already one letter has, Your Lordship.
One second,
written-
one second, I'm just reading the last order.
Yes, Your Lordship.
Okay.
Your Lordship,
Hmm?
as per Your Lordship last dated regarding the verification of the authenticity of marksheet, Your Lordship. Again, Your Lordship, process was, Your Lordship initiated regarding the official document verification on, at the website portal, that is csjmu.ac.in. And thereafter, Your Lordship, university had replied it through the aforesaid portal on dated 4/5/2026 by giving one remark that fill all correct marksheet details passing year, fill wrong. Whatever Your Lordship was provided as a record, Your Lordship, we have entered it, Your Lordship, in the website portal. But again, Your Lordship, it was showing it was wrongly filled up.
No, that was the last
Yes, Your
instruction.
Lordship, I'm coming through, Your Lordship. Thereafter, after getting all self-attested copies of marksheet and certificate in respect of the petitioner, that is Salim Uddin Ahmed, was shot by Your Lordship giving one issuance of office letter, number dated so and so on 5/5/2025. And he submitted the same, Your Lordship, by wide application dated on 5/5/2026. After receipt of his self-attested copies, Your Lordship, and certificates, marksheet and certificates, again it was re-uploaded in that portal itself. And again, after re-verification on that 7/5/2026, again it was rejected by giving same remarks as earlier, Your Lordship. Fill all correct marksheet details, passing year, fill wrong. The documents which we have filled it, it was given by him, Your Lordship, by attesting, self-attested. And thereafter, Your Lordship, it was against, Your Lordship, portrayal was again rejected it. And moreover, Your Lordship, it was seen that the details have carefully entered in the documents verification portal based on the details of marksheet submitted by the petitioner, that is Solimuddin Ahmed. And the said university has rejected the request by giving the same, Your Lordship, remarks. And a copy of a screenshot has already been provided in that, Your Lordship.
No, I cannot understand. I cannot understand. Initially, when this last order was passed on 6th of May, it was already communicated that certain things were wrongly filled.
Yes, Your Lordship.
Marksheet details were not complete and it was wrongly filled.
Yes, Your Lordship.
And so there was further, and what documents were again sought for
Your
submission?
Lordship, document will be very much necessary, Your Lordship, for a provincialization. And
Now, what
that
is the
full
latest
stop.
instruction?
Latest instruction is this only, Your Lordship.
But
For
this-
this, Your Lordship, Chhatrapati Shahuji Maharaj University, Kanpur is a necessary party, Your Lordship. Second page, we have highlighted it because from our end, it was coming to the same, Your Lordship. Same rejection was giving, Your Lordship, and same remark has been given. So here, Your Lordship, Chhatrapati Shahuji Maharaj University, Kanpur is a necessary party in the aforesaid case for proper adjudication of the matter.
What was the matter about, Mr. Sarkar?
Pertains to in-charge principal of the
In charge principal.
For the post of principal, Your Lordship.
kindly see page 30.
Now, whether these instructions are sufficient,
So I am done.
you do one thing, you give the instructions to him, let
Yes,
him
Your
go
Lordship,
through,
I will provide them.
and then
Or
we
Your
will go
Lordship,
look into.
I could file this by filing one affidavit, also, Your Lordship, because here Your Lordship is that Chhatrapati Shahuji Maharaj is a very necessary party.
No, no, that
to
is not
every-
required. Why should we implead them?
I am coming, but kindly allow me to think. Please 32 for a moment.
Hmm.
Serial number
32.
two. Serial number 2, page 32.
Page 32.
32, last page.
Abdul Kader.
No, page 32. I am Solimuddin Ahmed, serial number 2.
2. Solimuddin Ahmed.
Yes.
Yes.
Next, Lordship, senior Hindi teacher, then date of birth. Now, Lordship, kindly see MA degree. In following number is MA. Lordship, kindly see.
MA, yes.
Qualification.
Qualification.
Year of passing 2007. From Chandramohan Jha, Chhatrapati Shahuji Maharaj University, Kanpur. Yes, permission, NOC. With due permission, Lordship, petitioner prohibited.
So this MA degree was obtained during the service.
Yes.
And after
obtaining
receiving NOC.
NOC. Now, Lordship, BA degree, 2017, Government Beauty College, Kualpara, yes, on deputation. And Lordship, this is the seniority list prepared by the IC principal Lentishinga, SS school.
Now they are questioning the
inspector of the school. So insert principal is the inspector of this right now. He verified updated all the status of the petitioners after verifying all the documents. Now, Lordship, my senior friend, my friend Lordship saying he uploaded the mark sheet, not the certificate, part certificate. Lordship, we have arranged the part certificate, page 14. My mark sheet is not required, Lordship. My part certificate, whether my part certificate is genuine or not, that may be verified. Page 14.
This is your pass certificate.
Yes, Lord.
This is by Chandrapati, what Chhatrapati Shivaji something? Chhatrapati Sahuji.
Yes.
So this is to certify the obtained a degree of Master of Arts in his university. MA. MA, was it MA? Yes. And examination second division. So this certificate they can verify.
Yes, Lord.
Not the mark sheet and all.
Not required, Lord.
But mark sheet and all, they can see.
Even Lordship, if they are
So let her file an affidavit bringing into record this.
case is pending now
Your
for
Lordship.
last 6 months, Lordship. And now they are in every day they are raising another questions, Lordship.
Your Lordship, 7 point, Your Lordship.
Lordship, in the similar city.
I would like to file my affidavit here, Your Lordship, because every time already it has annexed it, Your Lordship, and remarks remarks can be seen, Your Lordship. All mark sheet details passing here filled wrong, Your Lordship. Every time Your
Feel
Lordship.
wrong means wrong by the petitioner.
Yes, Your Lordship, might be there is some discrepancies, Your Lordship. That's why, Your Lordship, they needed to meet one party. Why they have not arrayed, Your Lordship, this Kanpur University amended as a party, Your Lordship. They have not.
Acha, then they, in that case, they'll have to implead all from school authorities to college authorities, not required.
Your Lordship, only arising problem is that this university obtained a mark sheet, Your Lordship. So, Your Lordship.
Acha, who rejected your candidature? You are praying for appointment as an in-charge principal or principal, whatever, district-wise or whatever it is done. So why, you had filed your representation that was rejected? On what ground they have rejected your?
Not rejected, it is pending, Lordship.
No, why have you come to the High Court?
So they are, despite of you being a
Qualification.
senior most teachers of the school, they are not appointing me as a in-charge.
Who is working as the principal now?
No principal, in-charge inspector of school
IS
right now
will-
running.
IS will charge.
From last
it,
1
Your
year.
Lordship. I would
More
like
than
to
1
file
year.
What is this impugned order of 3125?
Do you know that?
Allowing the inspector to act as an in-charge.
Yes, Lord.
IS will
Yes.
operate, Your Lordship. I
No,
is
sir.
in charge.
So I,
Show me that impugned order.
Lordship, before impugned order close, 19 may be seen for a moment, Lordship.
19 only I have taken out. So director.
19, Inspector of Schools, Lordship, issued this letter to Director of Secondary Education, Lordship. This is the prayer of the Inspector of Schools. Kindly may be seen.
IS is the official, your lordship, appointee, your lordship. How he is objecting it, your lordship?
Okay. So the inspector has
So
written to the
Inspector of
director
School,
to
Lordship,
appoint.
suggested to
Appoint.
appoint. Now, next page, Lordship. Director appointment, appointing the IS himself. By the
So why was this step taken instead of candidates, instead of
Your
other head
lordship,
teachers? This is what you are questioning.
your lordship,
Despite I am a senior most teachers be eligible, having requisite qualification, they are not appointing me, Lordship.
So according to them, your certificate was fake.
Yes, they are questioning my certificate, Lordship. Despite that was, we have obtained my degree was obtained after taking due permission from the authority in the year 2007, Lordship. Long back in the
Acha, respected when our ex-principal submitted.
no affidavit filed, please.
Lordship, similar situated cases, Lordship, I have
Your lordship, let
Lordship,
me file our, allowed to
one
file our
paragraph,
affidavit.
Lordship, I
What English you have written? Let's see in Annexure 8.
annexer.
Annexure 8, page 21. Respected when our ex-principal submitted the seniority list in your office, I had lost my MA permission order. Now I have found my MA obtaining permission order. My God. So he had lost his pass certificate of MA.
From his position, it was not, but it was in office, Lordship.
That's
Subsequently
why, your
collected
lordship,
from
they
office.
are not, your lordship, giving that certificates, your lordship, after being asking again and again from the
So
department.
it was subsequently recovered from the Lordship.
There is no
teacher.
affidavit, right, by you?
No, your
No.
lordship.
No, let her file an affidavit
Yes,
showing the
lordship.
reason why he was not appointed as an in charge.
Your lordship,
In a
yeah.
similar situated cases.
No,
Lordship.
your lordship,
No, no, I'll take it
file
up.
our
Because
affidavit.
unless I can see some reason why his candidature was rejected,
Yes.
Yes.
how can I reach to any conclusion? Here, simply the inspector of school was appointed to was allowed to take over the charge of in charge principal, but no reason is mentioned why they are not selecting amongst the head teachers. Right.
Right.
And then inspector of schools writes to the director saying that you do something with the teachers. He doesn't want to hold the post.
Yes.
So why the other people in the seniority list are not being considered?
That is the question.
So let her file an affidavit. Our reasons are not forthcoming. Right.
Yes.
Heard Mr. A.T. Sarkar, learned counsel for the petitioner, and Miss P. Das, learned standing counsel for secondary education department. Miss P. Das has placed an instructions today, but it is directed that the learned counsel may file an affidavit incorporating the said instruction or any other within within the next date of listing. In the said affidavit, the reasons for not appointing the petitioner to the post of in charge principal has to be highlighted. In charge principal or principal koi diya, huh? List this matter on 12th of June.
After 3 weeks, your lordship.
12th of June, enough time.
Yes, your lordship.
1, 2, 3, 12th of June 2026, by which date an affidavit should be filed by the respondent.
Maybe kept as hard in part.
Uh-huh. No, hard in part. No, what have I had? small matter.
Your lordship, on two occasions, your lordship asked for that.
But then let's see, it might come before me only. Again, I've said list again on so and so, 15th of, all courts are same, it's okay. Nothing much you have said, it's okay. 12th of. Thirty-two to here, sir. Aye. Matibo, sound? Yes, yes, Mr. Borwa.
My lord, in the IA, my lord, the respondent file,
Hmm.
the authority, my lord. The school authority, they have not filed affidavit, my lord.
Aye. This is for what? Aye is for what?
IA, my lord, there are some vacancies, my lord, arising in the LP school, my lord.
This is by way of an IA.
Yes, my lord, why, my lord, main case is pending. So some vacancy arose in the state sector. So from Dima Hausa district, my lord, initially they were appointed in normal sectors.
No, some vacancies arose means those were future vacancies.
No, due to retirement.
Acha.
Retirement
Anticipated.
And they, from there, the normal sectors were moved to the state sector.
Acha.
As per well-recognized practice.
So you will file your affidavit in the IA or it is filed?
Not filed, my lord.
There is some application here, what? Oh, this is it. IA, two in numbers. There are two IAs or what?
No, my lord, only one IA, IA civil.
187.
Yes,
There are two copies.
that's.
দুটা কপি কিয় দিছে হেমেন্দা? এয়া চব এটা okay. So here you need to file your affidavit.
Our, my lord, prayer is that, my lord, if they cannot deny our right, my lord, but by their silence, my lord, they fill up this post by way of, well, new contractual employees. So our existing right as a 30 years old teachers, it will gone, my lord. That's why this IA, my lord.
So you were appointed 30 years back
Yes, my lord.
as ad hoc
Sorry,
casual,
23 years back.
as temporary.
Not temporary, my lord, under council, my lord, in Sea Hills, as a normal sector teachers.
Then your services were never regularized.
Then, my lord, when the vacancy arises in the state sector, as I am pointed in page 16, they are as per the well-recognized principle, they bring as per seniority, they adjust, my lord.
To the normal sector.
No, to the state sector.
State sector.
Now, what has happened, my lord, the authorities, they never file affidavit, nor disclose the number of vacancies. They, what they, my lord, they by a process of pick and choose, my lord.
They are appointing contractual people.
Contractual teachers. Favorable to them, my lord.
Lordship may grant me some time, I will.
So they will not file affidavit. In the main case also, they have not filed. The respondent 5 is the person, my lord, who issue advertisement.
Acha, by the last order, you were supposed to get the instructions today. Huh?
Yes, Lordship.
You have.
And get that instruction.
As the petitioners are seeking an order not to fill up the vacancies from non-planned teachers.
This post should be, my lord, they should not, my lord, fill up, my lord. From
So on the
context.
last occasion only, they did not get an interim order because you were supposed to place the instructions. Today, when the matter is called up, no instruction. And what happened to 18.2? The list the matter on 18.2, 18.2 matter did not come up. Okay, heard Mr. B. Borwa, learned counsel for the petitioner.
T. Sharma for 4 and 5. Lord.
And Mr.
T. Sharma for respondent.
C. Sharma, learned counsel for respondent number 4 and 5. On the by the last order dated 4/2/2026, Mr. C. Sharma, appearing for respondent number 1, 4, and 5, right,
Lordship.
was directed to obtain instructions and place on the next date.
Lordship, I am for only 4 and 5.
Earlier it was written 1, 4, and 5. 4 and 5, likhiba, not 1. However, when the matter is called up today, Mr. Sharma prays for further time to place the instructions. Although the said prayer is allowed, But it is further directed that the council should place the necessary instructions or file the affidavit if instructed by the next date fixed positively. List this matter on 10th of June. Right? You have to place the instruction or affidavit positively. Eh, on having if the respondents fail to get the instructions or file affidavit, this court would be constrained to hear the matter without the same.
On the number of vacancy in the state sector, they never disclose. On the number, that is my prayer, my lord, they will never disclose. That is the,
File the affidavit disclosing the necessary facts.
yes, ma'am, number of vacancy
File the affidavit disclosing the necessary facts
state sector,
also in respect of vacancies available
in the state sector.
in the state sector.
I'm obliged.
Your for responding to entry.
Oh, did you? Mr. So-and-so, what's the name?
As possible.
So-and-so for respondent
For.
on behalf of
On behalf of RM.
RM Das, huh? For respond number 2 entry. Okay. Present will लिख दो. Yes.
Obliged.
33, 34 কি হল? Time ললে. And John, 35. Oh, this is the last matter. আর এটা আছে. Yes. আৰু হেইটো কি হল? 37. এটা এটা আছে. Yes, 35.
Also matter pertains to service matter where I am challenging the appointment and promotion of respondent number respondent.
Ready for hearing? Ready for hearing?
Yes.
Councils are there? You have gone through?
Yes.
Hmm.
I think BTC council. I'm told that he has been handed over the brief today itself.
No, I'm not able to hear. What? Shout, you're a young person. What? Raise your voice.
I'm not fully prepared, Lordship.
You are for respond number?
I'm for the BTC, Lordship.
BTC.
Yes, Lordship. I can go to our affidavit. Our
BTC,
affidavit
there are so many senior councils.
Senior standing council, 1 senior standing council, 4 standing council.
So, not prepared.
Otherwise, the affidavit is on record.
Affidavit is on record or has already been filed or affidavit. I can go through this affidavit.
You can go through this affidavit and do. Right.
Lordship.
This is 24 matter. 2 years have gone by. Okay, let me hear, Mr.
So private respondent. Necessary.
Yes.
Lordship, I'm challenging the selection and promotion of.
I'll make it part-heard, huh? Because I have to rise little early.
Got it.
I'll take it up again tomorrow. Right? It will do?
Yes.
Yes.
So I'm challenging the selection and promotion of private respondent number 7, Lordship, which is in violation of Rule 14 of the Assam
You are
Secretariat.
challenging the appointment of R7.
Yes, Lordship.
What is your prayer?
My prayer is that
How are you aggrieved?
I am senior to the private respondent number 7, and as per Rule 14 of the Assam Secondary Education Provisional Rules, Service Rules 2018, the Departmental Promotion Committee has to consider seniority and 3 years ACR. But they have done the minutes of the selection committee have passed results and made selection list based on the interview marking, which is totally in violation of Rule 14.
DPC had done that.
DPC has done that. But till date, the BTC has failed to produce records of the DPC minute before this honorable court. Neither in the affidavit nor otherwise they have produced it in spite of the order in the passed by the court that it should be produced before the court.
Acha, let me go through the records. What is there?
First, I'll take your lordship to Annexure A regarding the petitioner hearing before Lordship, page 17. This is my appointment letter, Lordship. My appointment was done on 8th of December 2010 as the assistant teacher and posted at Barkola High School.
As assistant teacher.
Assistant teacher, Lordship. If I may read, Lordship, subject to discharge at the time without notice and assigning any reason thereof, Miss Runumi Priya Devi, daughter of so-and-so, is hereby appointed assistant teacher and posted at Barkola High School in the pay scale of so-and-so and grade pay scale so-and-so, plus other allowances. That is the thing. Then Lordship will find annexure B, page 18, that's the two-type copy is my joining report.
Joining report.
Joining report, Lordship.
This appointment was temporary, but right?
No, Lordship, permanent. Not temporary, permanent appointment.
Grade pay.
Grade.
Scale of pay and grade pay. Okay.
Yes, ma'am. Then Lordship may turn.
What is this undertaking in the end? I understand and accept that government servant joining the new service, new pension.
Yes.
So, okay, new pension scheme, she is governed on. Okay, then she has joined.
I joined on 13/12/2010. Lordship will find out page 19, annexure B. Down below is my date of joining.
So the joining is 13/12/2010.
Lordship.
Then?
Then your Lordship may come to annexure D, page 21. This is the appointment letter of private respondent number 7. The date of appointment is same, that is 8th of December 2010. But she joined subsequent to me on 18/12/2010.
So it is subject to joining?
Yes, Lordship. Seniority is determined based on the joining law.
Where it is? Joining can be later, but appointment date is the same.
Appointment same, but based on joining seniority to be determined. That's as per the rules.
So join when?
He joined on 18/12. This your Lordship will find annexure E, page 22 is the notification of gradation list. On page 23, serial number 46 and 47 your Lordship will find. 46 is the petitioner and 47 is the private respondent number 7. Barkola
18/12.
degree, then.
Okay, 18/12.
Yes, Lordship. My joining is 13/12 and the private respondent 7 is 18/12. So according to this gradation list, I am senior to the private respondent number 7. Then Lordship will come to page 25, annexure F. The then regular. Page 25, Lordship. Annexure F. Upon retirement of the then headmaster, the petitioner was given in charge headmistress of the Barkola High School, Lordship.
In charge headmistress.
Yes, Lordship. In exercise of power conferred to the Director of Education, so-and-so, Runumi Priya Devi, senior most assistant teacher of Barkola High School in the district of Udalguri under BTC area, is hereby appointed to hold the charge of headmistress of Barkola High School in addition to her normal duties, with effect from the date of taking over of the charge of the headmistress. Vice Dimbeswar Bhagawati retired on 31/12/23 till regular headmaster is posted.
Okay. She was appointed as in charge headmaster.
Lordship.
Then?
Then, Lordship, for regular appointment of the headmaster, the interview was called.
Then she joined as a in charge headmaster.
Joined as an in charge headmaster. Then, Lordship, page 27, which is annexure H. The interview for promotion to the post of headmaster, headmistress of provincialized high schools under Baksa and Udalguri district of BTC area. It was called for, which will be held on 19 to 24 in the government CTC Kokrajhar as per notification number so-and-so dated 13 February 2024 is rescheduled on 22/2024. Based on this interview, I participated as well as
Actually, headmaster, headmistress is not a promotional post.
it's a promotional post.
Promotional post.
Promotional.
Acha. I thought direct recruitment. Like in the case of principal, in charge principal under 2017 rules.
But here it's a promotional post, not present rule.
So interview for promotion to the post of headmaster, headmistress was postponed.
Postponed to
22.
22.
Mm.
22 it was held
Mm.
for Udalguri district, for which the petitioner is concerned with. And after that, based on the departmental promotion committee minutes, immediately thereafter, Lordship will find page 28 annexure I. Ceremonial
Wait, one
distribution of
second.
promotion order.
1 second. Interview for promotion was to be conducted. An interview for promotion to be held on
19 was rescheduled on 20th.
On 20.
20 February 2024.
Then what happened?
We participated. Krishna as well as phone number 7 participated. Then, based on the recommendations, the immediately BTC has issued this ceremonial distribution instructions, which will also be find at page 28, annexure I. With reference to the subject matter above, I am to inform you that as desired by the Honorable CM BTC Kokrajhar, the ceremonial distribution of promotion order to the selected candidates for the post of headmaster, headmistress of provincial high schools under BTC area is to be held on 14/3/24 in the auditorium hall of BTCLA at 5 p.m. Therefore, you are requested to inform the selected candidates under your jurisdiction.
2024, right? 14/3. So ceremonial distribution.
Yes, Lordship.
Yes, then?
Then Lordship will turn to page 29, annexure J.
So selection is made.
Selection is made, Lordship.
Approval for promotion to the post of headmaster.
Lordship.
So director has to approve.
Yes, Lordship. Now, at the time of filing of the writ petition, Lordship, we could not annex the entire selection list, which I'm producing here, which is also part of the record filed by the respondents in the affidavit. See, Lordship's convenience, I'm giving this selection list.
This is the select list.
Select list, Lordship.
You have annexed part of it here.
Yes, Lordship. That is on annexure J, page 29. Although I could not annex the entire list, so I'm referring to it. Lordship may turn to last page, which is for Udalguri district, serial number 17. Tapesuri Boro, Barkola High School, and selected school is Barkola High School. So that
Is the petitioner here?
She is private respondent number 7.
Petitioner's name is not there.
No.
She was not selected.
She was not selected. She was not selected because based on the interview, they have given marks. And based on that marks, as stand taken by the BTC in their affidavit, based on the marks, private respondent number 7 secured more marks than me.
What is the criteria for promotion to the post of principal?
Seniority and consideration of 3 years ACR.
Only seniority. And the other requirement? ACR for 3 years.
3 years ACR.
3 years ACR.
Lordship.
So only seniority, not seniority come merit or anything.
No.
So
Merit
only seniority,
consideration-
then why examination?
In my humble submission, merit consideration is based on the ACR. Nothing else.
So examination was not supposed, was not
supposed to-
required.
Not supposed to be. That DPC had to consider the ACR. They should have called the ACR from the school. And so have considered that for evaluating the merit. And so far seniority is concerned, that has to be there. So that is the whole criteria. Now, what they have done it otherwise.
So in case here the criteria should be if two persons are of same merit, if ACRs for the last 3 years is good, and another is also good. So within them, the senior will get.
Seniority will come. Absolutely.
Mhm.
That is the whole criteria.
So, but then that was not followed.
That was not followed.
And interview was held.
Interviews were held, and based on interview, they allotted
Marks was allotted.
which was not permissible as per the rules. Even the DPC did not have power to allot marks based on the interview.
That was not provided for anywhere.
No. I'll come to
DPC will consider the ACRs and then senior will prevail.
Exactly. That is the rule.
Then? So the petitioner was not there in the select list.
Not
Then?
Lordship. Thereafter, this promotion order was for private respondent number was issued, which your Lordship will find at page 30 and except
Wait for 1 second. Petitioner not there. Then what happened? Promotion
Then-
order was released, issued.
was issued to private respondent number 7, which is on page 30. and
Waited
except
demand, Srimati Tapeswari Bora is hereby promoted to the post of headmaster. Okay, then promotion order follows. Then?
Now, for the time being, I take a Lordship to the provisions
So
of
that is your case, you were not considered.
Lordship.
Rules were not followed.
Rules were not followed.
What does it AO say?
Lordship, for the time being, may I take a Lordship to the rules? Assam Secondary Education Provided Service Rules 2018.
Ayo, এখানে হবো। এখানে হবো। Education manual, right?
Education manual.
Yeah, এখানে হবো। Yes. Page number?
Lordship, there is,
Same book, page number?
35. The small book, Lordship, which I am having, so page 35.
It's a small, same book, I think.
Same.
Page 35.
Otherwise, Lordship, Assam Secondary Education Provisionalized Schools Service Rules 2018.
Service rules.
Yes.
This is rules only. Provincialized schools, rules 2018.
Lordship, Service Rules 2018.
Assam provincialized, right?
Lordship. Page 35.
কোথায় গো? হেৰি নাই, নাই। 2020, Assam Secondary Education Government schools, not provincialized schools. There are no service rules here. So,
Page 35.
Same book. So I can see the same book. 35 is a part of the act. There is no service rules. Service rules. इसमें देखिए service rules नहीं है. 35 years में तो service नहीं है. नहीं. देखती हो? That गलत से हुआ. Which section you are talking of?
Rule 14, Lordship.
Rule 14.
14. एक second.
Improvement to the post office.
On
एक
page
second.
35 of the small book.
Service rules only. लेकिन यहाँ पे service नहीं है देखो. ये तो service rules ही है. Okay.
Assam Secondary Education Provincialized Schools Service Rules.
Service rules is not, service word is not there in the top of the page.
Okay, it's
But otherwise the rules is service rules.
okay.
That is the mistake done here. वहाँ पे है ना. Same addition तो कैसे होगा?
Same edition. Size. is-
कैसे हो गया ये? देखिए यहाँ service नहीं है, वहाँ पे service है.
Maybe printing error.
Maybe. It's okay. Section 14,
Rule 14, Lordship.
Rule 14.
Recruitment to the post of headmaster, superintendent, and procedure thereof. The post of headmaster of a high school and superintendent of a high madrasa shall be filled up by promotion from the candidates among the. graduate
One
teachers.
second, Mr. Todin की रो. थोड़ा सा अलग है printing वगैरह. The post of headmaster of a high school shall be filled up.
Of high madrasa shall be filled up by promotion from the candidates amongst the graduate teachers as per district-wise seniority list. on recommendation of the district selection committee constituted under Rule 16(2). The selection of headmaster and superintendent shall be based upon seniority and satisfactory annual confidential report for last 3 consecutive years as per procedure provided under sub-rule 3. Then a lordship will find, provided that the seniority of graduate teachers shall be determined from the date of receiving graduate scale of pay by the respective assistant teacher.
So this is the relevant rule, right?
Lordship. Then I'll take your lordship to sub-rule 2, clause Roman 3. The district selection committee shall hold interview category-wise and prepare a panel of select list double the number of vacancies of the concerned district. The select list, Roman 4, the select list so prepared by the district selection committee shall be submitted to the state selection board. The state selection board, after necessary verification as may be required, shall prepare a district-wise select list equal to the number of vacancies and publish the same in the office notice board or in such other place as the director may consider fit and proper. After publication of the select list, the appointing authority shall issue promotion order from the approved select list. Now I'll take your
So why is the interview at all required?
lordship will turn
Category wise and prepare a panel of select list double the number of vacancies. Right. But the promotion criteria is seniority and 3 years SEI.
lordship. That is the only criteria. So that is the rule, lordship.
Yes, then
Now may I take a lordship to the affidavit filed by the BTC.
respond number 7.
Respondent number 4, lordship.
Respond number 7 is the private respondent.
Private
Who's appearing for private? You.
I was.
And page number, PTC's affidavit.
That should be running page 61, lordship.
Yes. So what does the BTC say?
Lordship, para 4, page number 62. That as regards the statement made in paragraph 2 of the petition, the Department begs to deny the same as being untrue. As the BTC authority has constituted the departmental's promotion committee, wide notification number so-and-so dated 1/2/2021 for the purpose of promotion to the post of headmaster administrator, which serves the same purpose as the district promotion committee, which is referred to under Rule 16.
For the purpose of promotion for the post of admin, which serves the same purpose as district referred to under, what is this? So DPC has referred under Rule 14, they want to say.
Yes.
Then
16(4) is the who should constitute the district selection committee. 16(4) refers to that.
But this is departmental promotional committee, same.
Lordship. As per Rule 16(4) and Rule 14 of the Assam Secondary Education Professionalized School Service Rules 2018. Then Lordship come to para 7. That as regard the statement made in paragraph 6 of the petition, the deponent begs to deny the same as not true. The post of in-charge headmaster is a process of temporary arrangement of department to run the school till a regular headmaster is made appointed, And further, it is pertinent to mention here that the process of selection of a regular headmaster can be made only through a proper selection procedure by the district promotion committee as per Rule 16.4 and Assam.
That is not disputed, okay.
Not disputed. Lordship.
In charge is a temporary arrangement and yes,
Yes,
then?
not at all disputed. Then Lordship may turn to para 19. I'll take to the relevant part, the last 6 lines, Lordship.
19.
Page 9, para 9, Lordship.
9.
Para 9 on
Yes.
page 64.
Hmm.
The last 6 lines, Lordship, starting a meeting. A meeting by the Departmental Promotion Committee, BTC, in regards to promotion for the post of Headmaster Administrators is Provincialized High School was held on 4/3/24, wherein 35 numbers of candidates were selected for said promotion to the post of Headmaster Administrators of the high school as per Rule 14.3, Roman 3, and the provisions of Assam Secretary to Province Rules 2000.
So, okay, name of the writ petitioner was not selected and then the post of headmaster, so and after review, who had applied for the post in interview board, writ petitioner had secured 35 marks less than respondent. Okay. So she was not selected because she got lesser marks.
Here they have gone other way than the rules by allotting marks for based on the interview only.
Which should not be the criteria.
Exactly. That's
Then?
the whole thing, Lordship. Then subsequent paragraph, Lordship. Further, the DPC for the promotion to the post of Headmaster Administrators for Udalguri district conducted an interview through interview board. It states on 19/2/24, but interview it will be 22/24.
Yeah, same things they are repeating.
It was rescheduled, Lordship.
Ah.
And prepared a list of panel of select list double the number of vacancies. Accordingly, the Department Promotion Committee had conducted an interview by forming 4 number of interview boards on 19/2/24 by taking into consideration factors such as service experience, ACRs, and performance in personal interviews.
These should not be the factors.
Exactly, Lordship.
Then, a prima facie, this is not the court's opinion, but prima facie, yes, by hearing you.
It is the admitted fact on affidavit by the BTC how they have proceeded, Lordship. That there remains the whole rest are the repetition of paragraphs, Lordship. And so they say that accordingly, private respondent number 7 was promoted. We have contended to this affidavit filed by the BTC, Lordship, by stating that the requirement was consideration of the ACR, but they have neither called the ACR nor considered the ACR. Specifically in our affidavit in reply, we have stated that, which has not been controverted.
So this is your case in nutshell.
Lordship, that's my case. And interestingly, Lordship, how the BTC has proceeded, Lordship, I'll just like to appraise the Lordship on by the dates. 4/3/2024 was the DPC minute recommendation.
Wait. 4/3?
2024 was the DPC minute recommendation.
The DPC recommendation.
Lordship.
Then?
12/3/24 approval of promotion was issued.
Approval by whom?
By the BTC for promotion of the private respondent. 13/3/24 promotion order was issued.
13/3.
13/3/24.
30.
1/3.
Oh, immediately on the next
Yes,
day.
Lordship. That is how they proceeded.
So promotional order. Then?
14/3/24 promotion order was handed over.
So fast.
That is the work how the BTC has proceeded for giving effect to the selection list and promoting the selected candidates. Against this Lordship, we immediately approached this Honorable High Court, and on the interview, status quo was maintained. Since I was holding the charge of in-charge headmaster, I'm still till date continuing the charge of headmaster. And the private respondent number 7 is still functioning as the assistant teacher. So that is the case, and there's a violation of Rule 14. In similar cases, Lordship, if I may refer, subject to what BTC submit, similar cases, Lordship will find, it would be 3 cases from another district, Lordship, Buxa district. This Honorable High Court, by considering the DPC minutes, have already held that there was a gross violation of Rule 14. And there was direction to reconsider the petitioners in those cases, Lordship.
As in respect of similarly situated other petitions.
Similarly situated other people, but district of Buxa, Lordship. Mine is district Udalguri.
Same criteria not followed.
Same consideration by the DPC without considering the seniority. First, Lordship, the case of Anwar Hussain versus State of Assam. The findings are on page para 10, 11, 12, 13, and 15. The fact is noted on para 12, Lordship. Page 16 of the order. To state in brief, the petitioner who is...
It's okay. Same things.
Lordship.
Fine.
Govinda following
Talukdar.
this, the other 2 judgments are also there.
Same. On the same line.
Yes.
Criteria not followed.
Criteria not
So what
followed,
was the
gross violation
final?
of Rule 14.
So final, what is the final
To
direction?
consider the petitioners therein for the purpose of promotion,
Consider.
Lordship.
And it was done.
As I'm told, Lordship, subsequently BTC has come out with an order where they have stepped to cancel the entire DPC recommendations.
And hold a new one.
Hold a new one
In consonance with the law.
in consonance with the law. But the direction was only to consider these petitioners before the Lordship in these particular cases who were senior to the selected candidate.
Even in Anwar Hussain, there is a direction for consideration.
Lordship will come to para 14 and 15.
Okay. Then, this is your
However,
case?
Lordship, however, in my case, I am challenging the select list only to the extent of selection of Barkola High School, which myself as petitioner and private respondent number 7 are concerned.
And this district-wise selection is, district is what district?
Districts are, Lordship,
The select list is prepared in respect of the entire district, right?
Pokrajhar, Chirang, Buxa, and Udalguri. Entire district, Lordship. 4 districts.
Where do I find this?
Lordship, I've given this approval of. Yes.
That was only I'm holding, but
Yes, the first page you will find, Lordship, the second column is Kokrajhar district, name of district.
name of the selected school.
No, the second column.
Acha,
Lordship,
name of district, Kokrajhar.
That is Kokrajhar. Then
Chirang.
next page is Chirang and Buxa. Buxa continues on page 3 and page 4 is Udalguri, Lordship.
You are in Udalguri?
I'm in Udalguri. I'm not challenging the entire select list, but I'm challenging only to the extent of selection of Barkola High School candidate, Lordship. That is my prayer. That I may be considered and promoted to the post of headmaster being senior.
Okay. That is your case?
That's my case.
So what has Mr. Biswas to say? No, first of all, BTC. BTC, I've already seen your stand that, you are there for. Seen your stand that interview board had given marks to each and every candidates. And according to the marks, the promotion was granted. That is your case. But that is in violation of Rule 14. Because what needs to be seen is the seniority and 3 years ACRs. Whatever is in the affidavit, that is your stand, right? It's okay then. Mr. Biswas, you proceed.
But your lordship may kindly come to page 13 of the writ petition. The
Page?
13 of the writ petition. the
13.
prayer made by the learned petitioners
Mm.
and the contrary and the other submission made just now that he is challenging only the selection of headmaster to the post of headmaster of Borkola High School, which is factually may not be correct. But here he
Quashing and setting
quashing
aside of impugn order.
issued by the Secretary Boreland Territorial Council Kokrajhar and the order dated 13/3/2024 issued by the Director of Educational Board so-and-so, the entire select list, my lord, the petitioner is challenging. If, my lord, your lordship, for a moment, my lord, if your lordship holds that he succeeds in the writ petition and select list, my lord, goes, my lord, the other candidates who have been selected, my lord, they will be deprived from a fair hearing, my lord, before this honorable court. One month, first submission. Second submission, my lord, he cannot be aggrieved by an order of promotion to the post of headmaster into a particular school, my lord. Because this selection procedure, my lord, has been conducted with the, my lord, district-wise. The promotional, the seniority list was, my lord, prepared district-wise. And there are other candidates too who have been appointed after 2010 who have been selected and promoted to the post of headmaster. They are not before this honorable court.
By this select list.
Yes, my lord. And the judgment, my lord, relied on by the learned council.
Select list will be valid for a year. For 1 year.
Yes.
So how can the subsequent appointments be made from the same select list?
My lord, they are, my lord, in the, when the, means, my lord, seniority list was prepared district-wise, as many as, my lord, 69, 70 candidates were.
Not seniority list, select list.
Seniority list, my lord, first. The gradation
This is
list.
not you are talking of, right?
No, my lord.
Acha.
The gradation
Seniority
list,
list,
first
yes.
of all, the gradation list was prepared. From the gradation list, my lord, for the entire district, my lord, the headmaster was selected. And that's how the selection list was prepared by the BTC, conducting an interview as per Rule 14. Because there is a provision in Rule 14, 6 clause 3, that interview will be conducted and the ACR would be seen, my lord. The annual confidential report will be considered and thereafter the appointments will be made. But so far as seniority is concerned, there is no dispute, my lord, to the fact that he is senior. And I joined 5 days later than him, my lord. There is no dispute. But so far as the interview process is concerned, unless he can show that there is a violation, gross violation and the process went wrong, because as per the rule, if I may take your lordship to the rule once.
Seniors interview both will.
14.3, interview, my lord.
That is why I've said that interview for the purpose of seeing the ACRs.
ACR, my lord.
For the last 3 years.
Yes, my lord.
But after that seniority.
Yes, my lord. He cannot be, my lord, certainly submit before this honorable court, my lord. He had a good ACR.
What ACRs he has,
yes,
that we don't.
whatever ACRs is available before the BTC, my lord, it will be considered. And whether his ACR is bad or good, my lord, it is to be considered by the BTC. That cannot be challenged by the petitioner here before this honorable court. And so far as the other candidates are concerned, if I may take a lordship to the affidavit of opposition. No, about again. Affidavit in opposition filed by us.
From affidavit in opposition from tomorrow.
Yes, ma'am.
I mean tomorrow, not from. Okay. It's an affidavit in opposition by respondent number 7.
7, my lord.
We will start tomorrow again. Today for 4:15 I have to rise. So, okay. Heard in part. List this matter again tomorrow. That is 20th of June. Okay. So this is part of Hemanda, the motion of the May, tomorrow. 20th of May.
Subject to lordship's convey, can it be on?
Hey, no, it's fresh in my mind. Tomorrow, let us take it up. We are going somewhere.
I had a family function lordship tomorrow.
You do this and go. At your convenience, we'll take it up. Family function will not be in the day.
Convenience, lordship's convenience.
Or as a first item.
Yes.
But there will be motions.
Immediately after motion, it can be taken up. Subject to lordship convenience.
No, it's okay. You also have a function. So immediately after motion, you come little late. Okay. Motion, we will take it up. When both of you are here, I'll take it up. Okay, how did list is tomorrow? 8 we are at half, huh? Let these papers be also here, huh? What about the other matter? I was asking again. Yes, 37. 37, we'll take it up some other day.
Hello.
Yes. Otherwise, ready for hearing.
No, this is ready for you.
We will take it up on a date of your convenience.
Well, next week.
As prayed for by the parties, list this matter on 2nd of June. Next day, there will be again holidays. Or Tuesday, we can take it up. 26th of May.
2nd of June, madam.
2nd of June. 2nd of June. 26. Out tonight?